Good morning, everybody. We will call the meeting to order for management audit interim meeting. First off, can we please have the roll?
Senator Dockstetter. Senator Ide. Here. Senator McEwen.
Excused.
Senator Olson. Here. Senator Rothfuss.
Excused.
Representative Lean.
Here.
Representative Locke.
Present.
Representative Rodriguez-Williams.
Here.
Representative Sherwood.
Here.
Vice Chairman Larson.
Here.
Chairman Knapp.
Here.
Mr. Chairman, you have a quorum.
All right, thank you. For all those attending today, hopefully you've signed in already. If you haven't, please sign in to the sign-in sheet. We do have just a housekeeping for decorum. You all look like a pretty mild-mannered bunch, but we'll go over this anyway. One of the rules we have, obviously, is to respect one another. No interrupting, no personal attacks, no booze, especially when I'm talking. And then also, if you could speak through the chair when addressing other senators and representatives' questions. I know it seems awkward sometimes, but we go through the chair. So that's really the only housekeeping we have. And so we will begin with our major administrative rules. And before we start also, I'd just like to welcome Senator Dockstetter to Management Audit. It's good to have you here.
Morning, Chairman, Vice Chairman, members of the committee. My name is Matt Petrie. I'm the administrator of the Research Division for LSO. I want to start with just a little bit of background. I know the last time that we touched on this topic was during our meeting of July 9th in Cheyenne. And so really the genesis of this is that Senate File 127 was passed during the 2025 legislative session. And in short, what that does is it gives the legislature more oversight over administrative rule making by agencies, executive branch agencies. And part of Senate File 127, what it did was it allowed us to take a little bit closer look at that legislation and potentially come back with some recommendations for changes to that law before it takes effect on July 1st of 2026. So that's really what we've been doing this summer. Of course, we met in May with a great deal of information. We kind of scaled that down a bit for our meeting in July. And what you have in your packet in front of you, and Mr. Anderson will touch on this in a little bit more detail, is you have a bill draft. And that bill draft really has not changed since our July meeting, with one exception. The one exception that I want to point out to you is it's at the top of page 4 on your draft. And again, this is 26 LSO 0106. So what you'll see at the top of page 4 is a staff comment. And what that staff comment addresses is that we may want to consider excluding rules that are required to comply with federal law. We talked about this briefly in July, and one of the things that we had talked about, and you'll probably recall this from our 2 previous meetings, is we looked at excluding emergency rules from the definition of major rules. Major rules are those rules that would basically clear a threshold in order to have we would conduct what's called a regulatory impact analysis. That's really what Senate File 127 calls for. So we considered removing emergency rules from the definition of a major rule. And then this staff comment would ask you to at least consider removing those instances where basically a rule is required to comply with federal law. Just to give you a little bit of background on that, changes in federal law, whether it's a new federal law or an amended federal law, basically require compliance in order to accept federal funding for a first time or to maintain federal funding of programs. So you'll have an amended federal law. It'll require a rule change at the state level in order to continue receiving, in most cases, federal funds that the state has been receiving. But I've got an even better example of that. Typically think of changes to federal law regarding illicit drugs. There are changes to that schedule, if you will, of illicit drugs on a very regular basis. And so what happens is when the federal government adds one of those illicit drugs to its list of drugs that can be, use of drugs, delivery of those drugs can be punished, that's a criminal offense. What they ask is that the state add that drug to its list as well through the rules process. The federal government only gives you 30 days to do that. And so the criminal division at the Attorney General's office deals with this on a very regular basis, and they have to turn these rules around very quickly. But I think that that's probably as good an example as I can give you of the types of changes in federal law that require amendments to agency level rules, promulgation of amendments to agency level rules. So I'll leave it with that. We also, of course, have, I think, new federal laws that require changes in state level administrative rules. Those new federal laws are obviously come to us less frequently than amendments to existing federal laws. But those two are the implementation of new federal laws typically give states time to amend their rules accordingly. And so what you'll find a lot of times with new changes, new federal law, is that the state is aware of those changes in federal law prior to their effective date. And so the state has that time to make those changes in their administrative rules. So at that point, I'll stand for some questions. I do have a couple of other items that I'd like to touch on just real briefly after Mr. Anderson walks through the bill. But that is, again, that is the only change that we have made to this bill draft since July 9th, and a change that we would ask you to at least consider in terms of exemptions to the definition of a major rule. Thank you, Mr. Chairman. I'll stand for questions.
Questions from the committee? All right, Mr. Anderson.
Thank you.
Oh, I think you'll have to use that mic. I think that was not working very well.
Thank you, Mr. Chairman. Good morning, Josh Anderson, Legislative Service Office. As Mr. Petrie noted, the committee saw this bill in the July meeting. We walked through it then, and it's remained largely the same except the addition of that one staff comment that he noted, and I'll touch on that as we quickly go through it. I'll just go through it again for the new member of the committee, as well as to refresh everyone's memory as we looked at this in July. So the first change is starts at the bottom of page 2. And what this would do, Mr. Chairman, is require the agency to identify these rules as major rules if they do meet that definition of major rules when they provide their notice of adoption of rules. The notice, if they are major rules, would be required to include a statement that the rules are major rules, a statement of the need for the major rule, and any additional information necessary for the regulatory analysis required by law. And that's the major rule review process that was adopted by the legislature last year. Then on page 3 there, then that also just requires the Secretary of State as the registrar of rules to adopt any rules necessary to ensure that state agencies provide that information necessary for that regulatory analysis. And as required in that new subparagraph M, again, requiring them to identify the rules up front as major rules. Bottom of page 3 then is the definition of what is a major rule. So the first change there is previously, those included emergency rules, as we discussed previously. Because emergency rules often become permanent rules, it would essentially be a double review of those types of rules. And so this would remove emergency rules from this process. So it would just be the permanent rules that would undergo the major rule review process. And then at the top of page 4 is the staff comment that Mr. Petrie noted. Again, considering excluding rules required by federal law. So you can see there, if the committee did want to go that direction, there's suggested language there that would just say a major rule means a rule other than a rule required to comply with federal law that result or is likely to result in one or more of the following. On page 4 there, then this is what it consists of a major rule. So the first in paragraph 1 there is a clarification of that dollar amount. Previously it was $1 million. This would change that to $200,000 per year, or another way to consider that was $1 million over 5 years, was kind of the discussion of the committee back at our first meeting. The balance of that page, Mr. Chairman, is the other way to become a major rule is significant adverse effects on competition, employment, investment, productivity, or innovation. That language is not being amended. However, as noted in the staff comment there, the committee could consider potentially removing that language, that it doesn't include any measurable benchmarks, which may make it difficult for agencies to look at that language and determine whether their rule is a major rule or not. So that's essentially the bill, Mr. Chairman, and take any questions.
Questions from the committee? Yes, Representative Lean.
Thank you, Mr. Chairman. Thank you, LSO, for coming today, and thank you for preparing this for us. My question is about that staff comment on the top of page 5. I'm recently reminded of a gentleman that's in our state that's fighting for a pardon for deleting a DEF system because of an EPA rule that they be on large vehicles. So I'm curious, if we were to adopt this language here that just bypasses us if the government's going to give us money for following their major rule changes, would that also be included?
Mr. Anderson?
Mr. Chairman, thank you. And Representative Lean, I apologize. I don't know if I'm 100% following the question there. If you could give me a little more direction, I'm sorry.
Representative Lean.
Mr. Chairman, thank you. On the top of page 4 in the staff comment from 10 to 14, it says, other than a rule that is required to comply with federal law. Well, there's a rule that was implemented, and we have a gentleman that's been facing federal prosecution for deleting DEF systems off of semis. So I'm curious to know, if we are to implement that staff language, is there an effect by federal law that will harm Wyomingites that may have unintended consequences such as that?
Mr. Anderson?
So Mr. Chairman, so I think all this language would do, if the committee did go this direction, would just remove that from this major rule review process. So it's that they would still go through the regular rule review process. And so the LSO legal staff would still look at the rules. They would provide the analysis to Management Council, and Management Council would be able to consider that rule as far as its legal consequences. So all this would do is remove these rules from the definition of a major rule, which would be that additional analysis, economic analysis that would be conducted through our research staff. So there would still be that legal analysis of the rules ongoing.
Follow up? Representative Rodriguez-Williams.
Thank you, Mr. Chairman. In regards to the staff comment on the top of page 4, my question really is surrounding, state sovereignty. And at times, as Representative Lean just mentioned, some of these big alphabet federal agencies adopt rules and regulations that tamper our freedoms within the states. How does this change perhaps impact our state if it were to pass? I mean, it states on line 12 that, it's specific to federal law, but often within law is, there's regulations and rules within these agencies. If you can elaborate on that.
Mr. Anderson.
Sure thing, Mr. Chairman. And again, I think, the state would still have the ability to, or, LSO would still conduct our normal rule review process where we're looking at the legal implications of the rules that are adopted by agencies. And this would just exclude those from this additional economic analysis because that process is a little more lengthy, I guess, and I think, this idea came from Mr. Petrie's review and his staff's review of some of the other states that have implemented these types of laws, and they have generally excluded these types of rules from their major rule analysis. So that's why this was added for the committee's consideration. And again, I think, there would still be the ability of the legislature to, and the governor to review rules for their legal implications.
Follow up? Any other questions? Yes, Senator Ide.
Thank you, Mr. Chairman. Thank you, gentlemen. Mr. Petrie, I'm going to go back to page 2 at the top where, we talked about eliminating federal law at that first paragraph there. I just want to make sure I understand this right. You used an example of, categorizing certain drugs at the federal level, just as an analogy to that. Would this, my experience in the legislature, we use way too much language to comply with federal law. A lot of times those federal laws are unconstitutional. Their powers are few and defined, and ours are, numerous, indefinite, whatever the Constitution says. So does that language, by eliminating that, in your opinion, that helps the state's sovereignty, as Representative Rodriguez just mentioned? Thank you.
Mr. Petrie.
Mr. Chairman, Senator Ide, from my perspective, it would not harm that sovereignty. The reason I say that is because getting back to what Mr. Anderson just touched on a moment ago, the federal government, obviously, if they're going to pass a new law, or they're basically going to amend federal law, there's kind of an implied consent on the part of the state. But at the same time, administrative rules that are promulgated by executive branch agencies in the state of Wyoming are typically called for in statute. So if you look at the structure of policy program in the state of Wyoming, obviously you've got the Constitution followed by statute, followed by promulgation of administrative rules, and then policy below that. So what we have is these rules that would be subject to these regulatory impact analyses are already called for in state statute. What Senate File 127 does, and what these changes do, is they basically bifurcate. They drop administrative rules into 2 classifications: those that have an economic impact of over $200,000 per year, and those that have an impact, a significant adverse impact, which is in the paragraph that follows the $200,000 threshold. And so it requires that review, and I think that that's what the legislature, I'm guessing that that was what the legislature's intent was in basically moving Senate File 127 forward. So now that does not remove the legislature's ability to basically vacate rules that an agency promulgates. As it stands now, that ability, the legislature has that ability now. Senate File 127 and even these changes strengthen that ability. So what it says is that if you've got a rule that has an impact of $200,000 or more per year or a significant adverse impact, that the legislature can take another look at that through this regulatory impact analysis. And if it deems that that rule was harmful or should be vacated, then the legislature can do that in the following session, which is a power that they have now. But I think that Senate File 127 strengthens that, and this language does as well. I think removing rules that are required by federal law is a way to focus resources on those rules that are called for in state statute that are either new rules or amendments to existing rules that could be deemed harmful, either in a financial way with an impact that's greater than that $200,000 threshold, or in a more subjective way that satisfies that definition of significant adverse impacts. But it doesn't hamstring agencies like the Attorney General's office when they have this direction from the federal government in terms of definition of illicit drugs that are subject to criminal prosecution.
Well, okay, Senator Ide.
Thank you, Mr. Chairman. Just real quick. Yeah, when you mentioned the illicit drugs at the federal level, it's still, marijuana is still category 1 or whatever, and it's illegal, but a lot of states just nullify that effectively because where's their enumerated power in the Constitution? It's probably why it hasn't been tested for the most part, but, and then, yeah, it seems like we just go down this path that we're always just looking at the federal government for substantiating our state laws. And I did mention, I think, few and defined and numerous and indefinite. I think that was in Federalist 45 or something that Madison said. And just everybody, we need to remember that the federal government's laws a lot of times are not constitutional. So thank you, Mr. Petrie.
Thank you.
Yes, Representative Locke.
Thank you, Mr. Chairman. So I just want to make sure I understand, but in some ways, the whole objective of this bill was to put this in our face, to make us do our job, if you will. That was the intent of this. In some way, and here, I'm just trying to get this clear in my head. Now here, the problem is these changes won't be in our face the same way. And that's easy for us to, it would appear to me that this be the case, because they won't fall into this category, even though they would normally do it. It sounded, I thought you said you guys wouldn't even do that major rule analysis on these rules. And do you do that assessment? And then how is this, when they are major rule changes, how does this, for lack of a better term, get put in our face so we can do our job? Because maybe these things, going back to what Senator Ide said, some of these things, we're not going, I don't think the blanket decision that the federal government's got control is the right answer. And so to me, this feels like it's removing these from being, us doing our job of doing a thorough review when they come across our desk. You know what I'm saying? Putting them on our desk. That's what it feels like this change would do. I just want to make sure I understand that. So thank you.
Mr. Anderson.
So Mr. Chairman, so I guess first thing to note, and as Mr. Petrie gave the example of the drugs, that's something that we have in our statute that says that our our Schedule I drugs will match the federal Schedule I drugs. So that's something that the legislature has adopted in our statute, that we're going to match our laws with the federal laws. And so in that case, because that's the direction, that's something that our Attorney General's office has to follow when they're doing their rules, that was a part of the reason, again, that we thought that it may be appropriate to exclude those, because it's kind of an automatic process that happens. And again, we still do the legal rule review of those rules. So we still note the change, and that gets, it goes out on our website, and our rule review gets given to Management Council, and they have 2 weeks to look at that before those rules get approved and go on to the governor for final approval. So it wouldn't take those rules out of the normal rule review process. It would just take them out of this additional economic analysis review process as a major rule. I don't know if Mr. Petrie had anything additional.
Mr. Petrie?
Mr. Chairman, I would agree with that. I think that, by dropping the threshold as it originally stood in the bill from $1 million per year to $200,000 per year, obviously subjects more rules to scrutiny. But I think it's also important to recognize, kind of stepping away from the example of the Schedule I drugs that Mr. Anderson alluded to, but also just compliance with federal reporting requirements for grants that are already on the books, that agencies are already using to fund programs. So you could have a federal program that there was a change at the federal level. The state needs to remain compliant with that change in order to continue their funding through that funding source. But again, the program is statutorily authorized in state statute, and part of that authorization is the understanding that the program is either fully or partially federal funded. So I think that by removing rules that are required by federal law from the definition of a major rule, that allows agencies to operate like we alluded to with the Schedule I drugs, but also for just continuation of their operations that are at least partially federally funded. And to be quite frank, it decreases the number of rules that the research division would have to conduct a regulatory impact analysis on, and then that the legislature would have to consider to determine whether they want to try to vacate those rules in the next legislative session.
Any other questions? So I'd like to kind of move on to the other staff comments on the bottom of page 4 and page 5, because those are pretty substantial, what I would say, either changes or add-ons to the bill. So let's talk about those too.
So sure thing, Mr. Chairman. So the first comment at the bottom of page 4, again, deals with that paragraph 2 on lines 23 through 26 of page 4. It's not being amended, but just pointing out that now that we're having the agencies identify these as major rules, there aren't any measurable benchmarks in that language. And so it may be difficult for them to say, so I don't know, just kind of highlighting that to the committee. If you guys do have anything that you want to see there, that might make it easier for an agency to be able to look at a rule, look at this language and say, yes, it is a major rule, or no, it's not. And then the second staff comment there, that takes up most of page 5 and 6. Back at our very first meeting, there was some discussion of requiring approval of the legislature before any rule or a major rule could become effective. That was not a specific request for language, so that's not reflected in the current draft of the bill. But that staff comment just points out some of the potential issues that would arise, primarily in timing. So for example, right now, the legislature makes a lot of rules effective immediately or on July 1. If we had to, but then we have rulemaking, if there's rulemaking required, I think the legislature would need to consider delaying those bills for, the effective date of those bills for a year, so that those would give time to approve any rules at the next legislative session. So that was some of the thoughts in there. Another potential alternative would be to kind of do it on a case-by-case basis. Again, in the effective date of specific legislation, you could say these rules, any rules related to this bill are not effective until approved by the legislature, so that it wouldn't slow down the effectiveness of rules of other bills that are unlikely to be controversial. But you could do that kind of on a case-by-case basis. And then finally, 3, just a note of potential separation of powers issues. I think we might have discussed that more at the last meeting, but if the committee did want to go to the idea of requiring legislative approval before rules are effective, there are some cases that have kind of dug into the separation of powers issues. And if the committee does want to go that way, we can certainly get into that a little more.
It looked like some conflicting cases there.
Yeah,
So
there are
I'd
examples
like,
both ways, Mr. Chairman.
I'd like comment or questions from the committee, because it is, I think one of the things that I did bring up for discussion was that when you make legislation, the rules are following that legislation's intent. And so sometimes it would make sense for us to codify those rules that goes along with the legislation instead of vetoing rules that are put in place without consent of the legislature, basically. I realize that you have the following session to negate those rules, but it would make more sense to me to prolong the enacting date, to have those rules presented so that legislator can either approve or disapprove of those rules. So just comments or questions from the committee? None? Okay. We will go forward. And is there any other?
I
Oh,
may.
I'm sorry, Mr.
Just a
Petrie.
couple of other comments on the report that was called for in Senate File 127. This is a report that's due to the Management Council by December 1st. And what we will attempt to do is get that to the Management Council for their meeting that's scheduled for November 18th and 19th. Will probably be a relatively brief report, because what you see in front of you in the bill draft is really the meat of changes that would be suggested or recommended to Senate File 127 before implementation on July 1st. So that will be the meat of that report. The other thing that we would include, and this is, my staff has put together just some kind of implementation, if you will. So when this bill takes effect on July 1st, we've put together some forms that we would then we would basically give to agencies that are promulgating rules that is addressed earlier on in this bill, where it basically, to some degree, we put the onus on the agency that is promulgating rules to tell us if they're major rules, or vice versa, to tell us that they're not major rules. So what we would include in that report to the Management Council would be just a draft form that we would then require agencies to complete at the beginning of the process when they start to promulgate rules. And that would really get the ball rolling in terms of that regulatory impact analysis. The Secretary of State's office will also need to revise a few of their forms that are associated with promulgating rules. And again, that language is included in this draft bill that basically requires the Secretary of State to ask or require agencies to submit that additional information when they start the rules promulgation process. That's the information that comes to us through this form that I just described, and that really kicks off that regulatory impact analysis process, if you will. So that would be essentially what the report to the Management Council would consist of. We would also probably hold a couple of meetings after the session with agency heads. One would be a fairly high level, just description of Senate File 127 and any changes that are made to it through this draft bill, and what would be required of them as a result of that. And then we would also give them an opportunity to take a set of rules that they have promulgated in the past and basically run those rules through this process so they could see how it worked. And then take comment from them on areas where they feel improvement was needed, changes were needed before we actually finalize the reporting process for agencies in order for us to do these regulatory impact analyses.
Yes, Representative Sherwood.
Thank you, Mr. Chairman. Thinking about that process, I'm grateful that the agencies will have an opportunity to sort of go through that and do some role playing. I'm wondering, or I'm imagining, at some point there'll be some uncertainty or unknowns. So just as when we see a fiscal note that says uncertain or unknown, and sometimes that's because of a lack of time to be able to really respond, what are we prepared to do if an agency is going through this process and they don't have the answers to those questions to be able to answer with certainty whether or not it's a major rule because of lack of information or lack of knowledge? I guess then what then in the process?
Mr. Chairman, Representative Sherwood, I think that I don't dispute that that situation could arise because you're absolutely right. When an agency is asked to comment on a new piece of legislation and they're basically asked to fill out that fiscal note form, a lot of times what you will get, and in all fairness to the agency, they don't know what those impacts will be, and sometimes it's a matter of timing in terms of turnaround, so they didn't have enough time to figure out those impacts. Or it's just, they simply don't know. And so you get a statement from the agency on a fiscal note that the impacts are indeterminable. So you could very well have that same thing in this situation. I think the benefit to agencies is that they will certainly have more time to work on those impacts through this process than they do in the fiscal note process. As we know, fiscal notes typically are turned around very quickly by agencies. Starting just the first part of next month, we'll be pushing out fiscal notes on proposed legislation, and agencies will be given, in most cases, about a week to provide those fiscal impacts. Of course, as you get closer and closer to the session, that turnaround time becomes 24 hours or even less in some cases. And so you're presenting an agency with a relatively potentially large piece of legislation and asking them to comment on the fiscal impacts. And so you do get those indications that the impacts are indeterminable. But I think that this process, though certainly not flawless, and we could have that come up, I think that it is, at least in terms of giving the agencies more time to assess those impacts, I think is beneficial to the agencies. Could we still have a situation like that? Absolutely, yeah. And and realistically, I think that that's where the research comes in. Is then does the research division attempt to determine those impacts? I would say hand in hand with the agency, because again, the agencies understand their programs better than Legislative Service Office staff. They're their programs, they're the subject matter experts. And so I think in a situation like that, the default could be that they would require a regulatory impact analysis, at least up to the point that you could determine whether they cross that $200,000 threshold, working with the agency. And then if they didn't cross that $200,000 threshold, you could stop the process at that point.
All right, follow up?
Thank you, Mr. Chairman. Do you imagine in that form the agencies will fill out that they'll have an opportunity to document the cost of compliance? So I know somewhere in our conversations in July, we talked about those direct costs. So things that are fees, licensing costs, equipment costs, operating costs, et cetera, et cetera. So essentially the cost to comply. Do you imagine that that will be part of the form the agencies fill out? Thank you.
Mr. Petrie?
Representative Sherwood, yes, absolutely. Yeah, we do want to know the impacts that agencies, the internal impacts to them, staffing, those kinds of costs, software costs, contracting costs potentially. So we do want to know those kinds of impacts. And certainly you have that as part of the fiscal note process as well. So agencies will not only tell you what the broader impact is of a piece of legislation on the economy as a whole, but then they'll also, if they feel that there are administrative impacts, staffing, so forth, they're given an opportunity to say that. And I think that having been in that position myself for years in executive branch agencies, agencies typically aren't bashful to tell you that they feel like a new program, a major change to a program, will require additional resources. So I think that they would be forthcoming with that, but they may also, if there's enabling legislation that calls for those administrative rules, they're given an opportunity to tell you what those administrative impacts will be on the front end, if you will.
Representative Locke?
Thank you, Mr. Chairman, and thank you for this, but I must be the slow one up here. I'm just trying to make sure I understand. But so in the process, when we're passing bills through, it's the departments or the agencies are coming in and saying, hey, we can implement this in this time frame, and you talked about the fiscal notes. Can you give me a pretty clear scenario where this time frame, let's just use the July 1st because we use that very often. Can you give me a scenario where these two timelines would collide? Because in the bill process, as we go through the committee, the departments are coming in and saying, hey, listen, we can't administer this, we can't implement it in 26, or, it's going to take us X amount of time to implement. In that process, the fiscal impact is in there, but where does this process now potentially cause the collision of the timelines? Can you walk through a scenario that makes that clear? That'd be helpful for me. Thank you.
Mr. Petrie?
Yes, Mr. Chairman and Representative Locke. You may recall, and I apologize, I didn't bring it with me, but at our meeting in May, we had put together just a one-page timeline that showed the promulgation process for administrative rules now and what it would look like because of the passage of Senate File 127. And you're absolutely correct in that those two timelines do collide. And this Senate File 127 extends that process, if you will. And Mr. Anderson touched on this in one of the comments that was made toward the end of the draft of 26 LSO 0106, where what this does is Senate File 127 does not preclude agencies from promulgating rules. What it does is it gives the legislature more information to essentially vacate those rules after the fact. So recall our conversation on emergency rules, and it's touched on in this document. And as Mr. Anderson says in the staff comment here, typically when a new piece of legislation passes mid-March, there will be a requirement that agencies promulgate rules in order to effectuate that legislation, basically to drill down a little bit further and get into the nuts and bolts of the bill. But those come with they rarely come with effective immediate dates when rules are required, but they often come with July 1st effective dates. So agencies typically only have about 3.5 months in order to get rules in place for legislation that has to take effect on July 1st. And that's where the emergency rules come in. So they basically put together a packet of emergency rules that only requires the governor's approval. But there is mirror rules that start working their way through the permanent rule promulgation process. And so they both start off at the same time, but those emergency rules enable the agency to do what the legislature has told it to do. You know, start this program July 1st. And so they operate under those emergency rules. Typically, agencies will have to do an extension of emergency rules because they're only good for 120 days. Regular rules take an absolute minimum of 130 days from start to finish, and that's if absolutely everything goes perfectly. So agencies typically have to extend those emergency rules for 120 days. But then your regular rules have worked their way through the process. There's been public comment, 45 days of public notice, public comment, and then those regular rules basically are promulgated. They're put into effect at that point. What this does is agencies would still follow that process, but it folds in this regulatory impact analysis into that time frame. And agencies will go through that regulatory impact analysis, and then that is reported to the legislature. And then the legislature can take a second look at not only the rules, but also the enabling legislation and say, you know, this isn't what we intended. The impacts are too great. Let's take another stab at this. And in the next legislative session, the legislature would basically have the ability, vacate is not the correct term. It's the term that I use. I think it's fairly descriptive, but the legislature would have the ability to basically negate those rules and ask the agency to go back to the drawing board. Or alternatively, if the enabling legislation were driving rules that the legislature found that it didn't like, then of course the legislature could attempt to amend that legislation as well. So it does, I don't want to say it extends the process, because agencies can still promulgate rules. It just gives the legislature more information in terms of the impacts of those rules, and then they can address it later in the next session. One of the things that we talked about in our two previous meetings, and you'll see this in other states, is legislative ratification of rules. And Mr. Anderson touches on that in his staff comment as well, that if you want to have the final say on rules before they are fully promulgated, then you have to kind of build in more of a legislative involvement. So what I'm saying is, and Mr. Anderson touched on this in his staff comment, that because that process now is relatively lengthy and these regulatory impact analyses extend that to some degree, you, instead of making enabling legislation effective July 1st of, say, 2026, you would delay that by a year. So your enabling legislation would become effective July 1st of 2027. Now, is that what you want to do when you pass legislation, or do you want that legislation to be effective as quickly as possible? So there's that scenario. Another scenario, and we saw this in our research of other states, is that you can have legislative ratification of rules during the regular rules promulgation process. But you would probably have to extend either the ability for agencies to operate under emergency rules and make that regular rules process a little bit longer. But then you would have, say, a legislative subcommittee that would meet periodically, and they would look at those regulatory impact analyses, and they would have that information that they want prior to the actual approval of those rules, the green light for the agency. I believe in July, I testified that one of the agencies that we looked, two states we looked at the most closely were Florida and Kansas. Kansas, basically their approach was probably the closest to what Senate File 127 calls for, but Florida has over a decade of experience in this, and it has evolved over the years in Florida. I can't remember which of those two states, but one of those states has a committee like I just described, and that committee met, I believe, 9 times in one fiscal year in order to move those rules, ratify those rules in a timely way so that agencies can get those regular rules in place as quickly as possible. As it stands now, Senate File 127 does not call for legislative ratification. It calls really for legislative review followed by possible changes in statute to address rules that are deemed to have too great of an impact.
Representative Rodriguez-Williams.
Thank you, Mr. Chairman. Mr. Petrie, you bring up an interesting point about other states that have had this type of process in place over the years. I don't know if you know the answer to this, but I'd just be curious if some of those states have improved, well, I'll call it improved, their bill draft process by creating more sideboards or more parameters within legislation that allows the agency to not drift away from the original intent of the legislation as this process has evolved, so to say.
Mr. Petrie.
Mr. Chairman, Representative Rodriguez-Williams, that's a good question. Unfortunately, I don't have a very good answer. I don't know, that's not something that we really touched on in our research to see whether an initiative like this changed the bill drafting process, as it were. I think you can certainly do that. I think that there's kind of a fine line between statute and rules. I think statute typically gives you the intent of the legislature and to some degree the content, but not necessarily all of the nuts and bolts that agencies need in order to effectuate those changes. Just to give you an example, at the Department of Health, a relatively large change in mental health services, behavioral health services, especially those services provided by community mental health centers. And that rules packet, when submitted to the Attorney General's office and to LSO for legal review, was hundreds of pages. Because even the enabling statutes for services delivered in the community mental health service setting in and of itself is page after page after page. So, I think you have to strike a balance between how much you want to put in statute and how much you want to put in rules. Rules essentially carry the same administrative authority as statute, but are probably a little easier to change, but they are legally enforceable. So just another thing to consider. Do you put the details in the statute or do you put the details in the rules? And I know that every state struggles with that.
And I have a question to that, because I think that's what was debated with this bill going forward is, in essence, rules currently are another step in the legislative process and have the value, just like you said, of law.
Right.
And so you may have an intent with a bill, but after the rules process, the intent may change, whether it's ESG or whatever it might be. And all of a sudden, you have to go back to the drawing board in session to amend a law's intent because of what could possibly be a rules placement. And so, because each one requires 130 days, correct?
Right.
You almost fall into the next session anyway. If you were, instead of July 1st, if you were to prolong your enacting date into a session date, that would allow the legislature, whether it's through management council or the body or another committee, to ratify those rule changes. And I think that's where I would like to go with it. It makes more sense to me that you're asking the legislator in the legislative branch to step up, and maybe we don't write every rule into law, but certainly we can stamp what's in place after rules to make sure that that was the intent of the bill. And I think it encourages legislators to be part of that process instead of just relying on agencies to interpret your law. So, comments?
And Mr. Chairman, oh, go ahead. Sorry.
Thank you, Mr. Chairman. I just want to put some more color on that skeleton. So LSO is active in the process of monitoring legislative intent, right? So after we leave session, a bill has passed and become law, the agency's promulgating rules. Through this process, this legal review process, LSO can say, you have misrepresented the intent of the legislation, go back and make those changes. So I just wanted to add that color of what happens when we're not in session, that those conversations about legislative intent are still occurring.
And Mr. Chairman, yeah, I would
Mr.
like
Anderson?
to follow on with that. So yeah, when we're doing the legal review, which is separate from this major rule review, the major rule review that we're talking about here is an economic analysis. When we do our major rule review, we look at, are the rules within the statutory authority and legislative intent? And so that's one thing we're considering, and then we send that to Management Council, and Management Council also considers, are the rules within the statutory authority and legislative intent? So that's one of the things we're trying to look at when we do our rule review. Now, oftentimes, some of the intent may be a little subjective, but, so we're looking at what does their rulemaking authority say? Because every rule that goes through, they have to have the authority to make those rules. So that is one thing we look at. And then we make our report to Management Council. Management Council can then, if we do recommend that a rule be negated, then they can forward that on to the governor, and then it's ultimately the governor's decision. And then if something gets through that process and through, and the governor were happen to do it outside of Management Council's recommendation, that's when we get into the idea of these legislative orders to negate those rules. And we've looked at that a handful of times over the years. It's fairly rare, but it has happened where we've considered that type of an action. But so that is something that we do through that existing legal review process.
And if that were to take place, what would be the process for that negation?
So there's a couple different ways that it's happened over the years. There is the ability in statute to do a legislative order to nullify the rules. So it'll just say, these rules are nullified. And if that were to pass the legislature, then those rules would be null and void. So that's one step that's happened, I don't know, not very many times at all. Then more common is to go in specifically to the rulemaking authority that the agency used to get those rules and make it very clear what rules are and are not allowed. So if the rulemaking authority was very broad, the legislature maybe didn't like the rules that were enacted, the governor may sign those into rule because they are technically within the authority that the legislature delegated. So then the legislature could go back in and make it very clear, narrow that rulemaking authority down. So that's kind of the more common process that's happened over the years.
Senator Ide.
Thank you, Mr. Chairman. Yeah, a little follow-up on Chairman Knapp's question on the process. That's what I was a little bit confused about. When you mentioned the Management Council blessing, so to speak, when does that happen in the process? Is that during, right after the session up until when the law has to go into effect July 1st, and you bring those to Management Council and they do whatever they do to push back or give the nod on that? Thank you.
Mr. Anderson.
Mr. Chairman, yes. So the rulemaking process is kind of ongoing all the time. So agencies are constantly throughout the year going through the process. So once they adopt their final rules, whenever that is, then LSO does our rule review. We have roughly 2 weeks to look at the rule, make our recommendations. That goes to Management Council, and then Management Council has 2 weeks to consider that. I'd say 95% of the time, we're just recommending approval. But if we recommend that they not be approved, then Management Council would have to agree with that. If they do, then that goes to the governor, and then the governor either follows that recommendation or he doesn't. If he doesn't, then he has to send a letter back explaining why. And then it's at that point where then we would get into to considering whether to do a legislative order in response to those rules. But yeah, it's kind of an ongoing process throughout the year. Whenever the agency just formally makes final approval of the rules, that's kind of when our timeline starts in the process.
Any other questions? Yes, Senator Dockstader.
Mr. Co-Chair, thank you. Before we leave, Mr. Petrie, you talked about creating these forms. Are we going to be able as legislators to track this process, see those forms? Is that through the management reports? How do we track what's happening there and have access to those forms?
Mr. Petrie.
Mr. Chairman, Senator Dockstader, you would have access to those. They would be public record. And really, again, that is, they're forms that agencies would submit as part of their rules package. And so that kind of kicks off the process. Basically, what we're doing is we are expanding responsibilities of agencies on the front end of the process. So when they've been told to promulgate rules following a piece of legislation and they start that process, they will essentially notify the the Secretary of State's office that they feel that their rules satisfy the major rule threshold, or they do not. If they do not, then we don't do that regulatory impact analysis. But we would still have that front-end information that they gave us to basically convince us that they didn't cross that threshold to become a major rule. So we would have that information on essentially every rules package. Now, if they do provide information that indicates it crosses that threshold and they are major rules, then that's when the research division of LSO digs in and essentially looks further into those impacts. And that would also then be reported to the legislature. And the way that Senate File 127 was passed, and this bill draft does not change that, is that in the following legislative session, if any legislator or any committee can basically make a motion to nullify those rules. As it stands now, the process is, as Mr. Anderson described it, where after that legal analysis that's always been required of LSO, then Management Council makes that recommendation to the governor.
So, but that process always leads up to the governor's decision on whether those rules are negated or not?
Mr. Chairman, the governor still has final approval of rules. This does not change that. Really what it does is it gives the legislature more information on impacts of major rules, and then gives them broader opportunity to challenge those rules in the next legislative session.
Any other questions? All right, thank you, gentlemen. Do we have any other agencies in the room that wish to speak to this topic? No? Any members of the public? Please come up and identify yourself, and love to get your comments.
That one didn't work.
Yeah.
Mr. Chairman, Joey Carenti with Rural Wyoming Matters. I want to speak first to a statement that Senator Ide made earlier about the language on page 4, line 12, the staff comment to include to comply with federal law. I would agree with you, and I think I agree with you. I don't like that kind of subjugative language saying automatically, as long as the federal government makes a law, regardless of our sovereignty or intent, we're just going to comply. I don't like codifying it, even though it's already technically in our Constitution, supreme law of the land. We will follow the Constitution and federal laws. But I think that language is captured in the paragraph below, where it already says any direct or indirect costs of not less than, proposed to change to $200,000. I'm wondering what federal programs, if we lost the funding, are we engaged in that's going to cost us less than $200,000 that we're really worried about? And then the bigger question, why would we allow the federal government to make a law for something we're going to comply to, give up our sovereignty for less than $200,000? So I think that kind of fixes itself. In that same paragraph, I think that language, if looked at a certain way, could answer one of Representative Sherwood's questions on kind of the X factor. What are the costs that are unknown or that we can't figure out at the time? If the way I'm looking at it is we have a situation where we can't find an economic impact of up to or over $200,000, especially if it has to do with federal law. Would the loss of that federal revenue or the cost of litigation, if the feds came after us for it, be over $200,000? I think every time the answer would be yes. So we could just assume that the language that is in the paragraph below meets the intent of the staff comment above, but we don't actually have to include it in the bill. But that brings me to my second point, that the word will on line 19 might need to be changed to a may, because it is an unknown. We don't know exactly what the cost of the loss of the federal program funding or the litigation would be, or it's moot. But if that approach is taken, it also kind of encompasses just about anything Wyoming would be engaged in with rulemaking. $200,000, a pretty low number. We're looking at about 34 cents for every man, woman, and child in the state. That's not including any of the businesses or tourism that comes through. We could pick up $200,000 of impact pretty quickly, which takes me over to page 5. And in the staff comment, I was at the last meeting virtually where there was a lot of discussion about the legislative involvement in this. And my biggest fear, big picture, is that eventually this somehow turns into a full-time legislature or a fuller time legislature because of the requirement to ratify or codify any of the rules coming forward. And when I say fuller time legislature, I think of the budget that's enshrined in our Constitution versus the practice of having a supplemental budget. There's no requirement to do it. In fact, last year was the first time in about 50 years we didn't do it, but it became regular practice to every non-budget year do that. Well, we also have procedures for special sessions. So even if the Constitution isn't changed to say, okay, we are going to allow the legislature to meet longer or full time, there are still processes within the Constitution that say every 6 months the legislature must meet in a special session to ratify or codify any of these major rules. And it's concerning. And to play devil's advocate, even if we don't do that and we wait for the calendar to come back around to a regular session as discussed, I'm wondering if there's any contemplation on the time on an already truncated legislative calendar that's going to take. Is there going to be a dedicated day in the schedule to ratifying? I mean, the Senate already does confirmations, so extra tasks are regular, but is there going to be, of a 20-day session, one full day will be dedicated to this? And is it just a vote it up, vote it down? Because if there's discussion and amendment to rules, we're looking at a whole lot of time in already truncated legislative sessions, including the standard that we have for deadlines. Certain tasks must be completed in the session by certain times. So now you're telling the legislature itself through the calendar, these are the things you will do by this time in a session where you already have this to do, plus the 600 bills that come down every session anyway. So just a few things to contemplate, and you'll probably hear me speak again on my concern about some of these efforts on multiple different bills, opening the possibility of a full or fuller time legislature, and how do we avoid that, still meet the intent of the legislation, and not chew up the valuable time we have in the current legislative calendars. And with that, Mr. Chairman, I'll stand for any questions.
Yes, Representative Lean.
Thank you for coming. Thank you, Mr. Chairman, and thank you for coming today, Mr. Correnti. My question is, do you have a solution aside from this legislation to be able to ensure legislative intent is followed out in the rules?
Mr. Chairman, Representative Lean, I have a few, absolutely. I know there was some discussion last time about having I believe it was in the emergency rules discussion, to allow them to go over a certain time frame, and that does bring it back into the calendar that we were just talking about that I played devil's advocate with. If we could find out what that calendar would look like first, it might be totally acceptable. I know that very first day of session, half of it is, I believe, the State of the State address and then swearing in. It might be workable to do it that way, but if it turned into a situation where we were debating and amending the rules, it could take a whole lot more. Otherwise, I would leave it to maybe a management council during the interim, not fully approving, but saying every 6 months the management council meets. I know they meet in April and then October, November-ish, and they say, until we can ratify this somehow through the legislature, the management council would really play a part in that. I don't know that we would want to cross branch and say as long as management council and then the top 5 elected agree. I mean, we're just looking at expanding more time for the legislature to be doing stuff that they should probably be focused on legislative tasks specifically. So probably no magical wand fix, but absolutely, if we could develop that calendar and there could be an agreement on how that would be executed in a legislative session after waiting potentially 9 months to ratify, I think that could be worked with.
Do you think that those rules would be, the major rules would be kind of the exception because it has to do with that threshold of implementing those rules? Do you think that would occur quite often?
I think with the current language and the proposal to bring it down to $200,000, everything's going to be a major rule. I think there's just going to be a truckload.
Any other questions? All right, thank you for your testimony. Is there anybody else from the public that wishes to testify? Anyone online? I know we have Betsy Anderson online from the governor's office. Does she wish to comment on this?
Mr. Chairman, we don't have anybody on Zoom participating on this agenda item.
All right. I will close public testimony then. What is the committee's pleasure?
Second.
Moved by Representative Lean, seconded by Vice Chairman Larson. Discussion on the bill. Yes, Senator Ide.
Yeah, thank you, Mr. Chairman. Back to the staff comment on page 4. If I'm understanding it right, and the comments that were made, I don't think we should acquiesce to the federal government on rules there. So with that, I would assume that we would not want that change to this bill. Am I correct, Mr. Chairman?
Yes, so that would be an amendment to restrict that language from the bill on 11 and 12 on page 4. That's not in the bill currently. I guess that is a staff comment, so it would remain as is. Yeah, okay.
Yeah, so Mr. Chairman, just to clarify, yeah, if you didn't take any action, those staff comments will just come out of the bill. So,
Okay.
yeah.
Any comments from the committee? Yes, Representative.
Mr. Chairman, do we want a motion so we can have a vote on this to vote it up or down? If so, I would make a motion to adopt the staff comment on page 4 between lines 10 and 14, just so we have a vote.
All right, is there a second? Seeing no second, that amendment, or that vote dies. All right, any other comments? Yes, Representative Rodriguez-Williams.
Thank you, Mr. Chairman. Just kind of want to open it up for discussion. On page 5, staff comment number 2. And it's a little interesting to me. Specifically I'm looking at lines 43 and 44. So it says, another alternative may be for the legislature to require regulatory impact analysis and legislative approval of rules on a case-by-case basis on the legislation or at the discretion of a committee. I was curious what that would look like. Would that, be this committee and a subcommittee under this committee? And if so, I guess my concern would be, I would want to add something in there that would require LSO to inform the committee when these come up, because it's not really spelled out in there. And then further down on that staff comment on number 2, lines 12 through 15, or 13 through 15, where it talks about the scope. If some of these rules are outside the scope of legislation, they could be prohibited through a legislative order. I'm not sure how often something like that has happened in the past, how often legislative orders are used through the process. I don't know that I've ever received an email that's informed me that there's a legislative order that's been enacted, or there's been a challenge. Just opening it up for discussion on that number 2.
Just in essence to that question, so would that, do you anticipate that case-by-case basis being drafted into a bill?
Mr. Chairman, yeah, I think that would be one way to do that, to kind of draft bill by bill. Any rules adopted pursuant to this bill have to be first approved by the legislature, and then we might need to add some kind of procedure in statute to kind of how that would work, dedicate a committee to look at that or something. So I think there's still some things to be worked out in that direction. But I think that would be one way, rather than requiring every rule to get ratified by the legislature. That may slow things down for non-controversial rules. But if there was bill by bill, if you thought the rules may be controversial, you could delay that. So that was just one option. But again, I think there might be some additional direction we might need to, if we want to think about going that route. As far as the legislative orders, we drafted one a few years ago in response to a rule, but it didn't get introduced. I think it's been maybe 80s or 90s since the last one that I'm aware of that was actually introduced into the session. So it's been very rare that we've used the legislative order. And the point of that part of the comment was just to say, if there was a rule that wasn't ratified, didn't require ratification, but it was still became controversial, the legislature would still have that option to go that route and negate the rule through a legislative order. So even if there was a rule that didn't require ratification, it doesn't mean that the legislature still wouldn't have a way to address that rule.
Follow up? Okay, other comments? Any other amendments? Yes, Representative Sherwood.
Thank you, Mr. Chairman. And I think just based on testimony that we heard during Senate File 127, when this was active during session, and then what we heard today in public testimony, I still go back to page 4, lines 18 to 21, that threshold. My gut says that this $200,000 is too low, especially in comparison to what other states around us are doing, and that it's going to create quite a regulatory burden and a backlog. And so just based on inefficiency, I would like for us to reconsider this amount and offer a $500,000 compromise as an amendment there on lines 20 and 21.
Okay, is there a second to that amendment? All right, seconded by Representative Lean. Discussion. Representative Lean.
Thank you, Mr. Chairman. I'm curious to know from the bringer, why 500,000 over 200,000, and when would you say that the public implementation of the financial burden is to be sought during rules? Is it the lower number or is it the higher number? Are we here to take care of folks at the local level in small business? Or is it just going to impact those that have larger industry across the state?
Representative Sherwood.
Thank you. I appreciate that question and the perspective. I guess I was thinking more about that threshold being impacted just from agency expenses, not necessarily even that impact to small business or business in general. And so thinking about businesses like certainty, right? So anytime that we create uncertainty through a process or a delays in a process, that stymies business development and growth. So just trying to find that sweet spot between, this includes that economic analysis is both the impact to state costs and private business cost. If we set the threshold too low, we're moving in at a slow pace and creating uncertainty for business. If we set it too high, you're right, we may be impacting small businesses negatively. So it's just a dance, and I just wanted to offer a compromise to that. And again, looking at what other states are doing, they're closer to that $1 million where we started. So $500,000 was my compromise.
Yes, Senator Ide.
Thank you, Mr. Chairman. Yeah, thanks for those two comments. The theory that I was under the impression was the $200,000 over a period of 5 years would be the $1 million. I think that was sort of the spirit of that amendment, if I'm not wrong. So if we changed it to 500,000, that would be $2.5 million under that conversation. Is that correct? Thank you, Mr. Chairman.
Representative Sherwood.
Thank you. I think if our intent is 200,000 over 5 years, we need to say that, because right now the language is an annual impact, so that I would interpret that as every year there's a $200,000 economic threshold. So I think if we're thinking about that more than an annual snapshot, we need to clarify that in the language.
Follow up. Any other comments to that? Suggestions? Yes. Senator Ide.
Yeah, thank you, Mr. Chairman. And the only reason I bring it up is that was some comments made by LSO and staff up there. So I was just trying to clarify those comments effectively too on that 5-year span instead of just an annual. Thank you.
All right, we have a proposed amendment and a second. All those in favor of that amendment, please signify by saying aye. Aye. All those opposed? No. Motion does not carry. Any other amendments? All right, seeing none, would you please take a roll call vote on administrative rules legislative review?
Mr. Chairman, this is a roll call vote for Bill Draft 26 LSO-0106. Senator Dockstader. Aye. Senator Ide. Aye. Senator McEwen.
Excused.
Senator Olson. Aye. Senator Rothfuss.
Excused.
Representative Lean.
Aye.
Representative Locke.
Aye.
Representative Rodriguez-Williams.
Aye.
Representative Sherwood.
No.
Vice Chairman Larson.
Aye.
Chairman Knapp.
Aye.
Mr. Chairman, you have 8 ayes.
Okay, that bill does carry. Let's take a 5-minute break. We're a little bit ahead of schedule, so smoke them if you got them.
That's a good one.
but anybody that was subpoenaed today, we'll do that at 1 o'clock. So I know your time said something on the subpoena, but it may be different. So thank you. All right, next on the agenda is the Legislative Service Office Performance Audit. Let's see, Josh, you want to give us the details on that?
So, Mr. Chairman, Josh Anderson, LSO. So there were a couple pieces to this at our last meeting. There was, a discussion of looking into having the Department of Audit do an audit of the Legislative Service Office, and I'll let them speak to that piece of it. The second part was a bill draft request to look at moving a portion of the Department of Audit, the Public Funds Division of the Department of Audit, under the legislature as a separate office, a separate legislative office with a separate director from the Legislative Service Office. So that's what this bill is, Mr. Chairman, 26 LSO 165, working draft 0.4. You'll see, there's a couple of ways we could have gone about this. This takes the approach, there's current kind of statutory process for government reorganization, and it follows that approach. So subsection A, beginning at bottom of page 1, and it would make all of this subject to approval of a reorganization plan by an act of the legislature. Under subsection C, the Public Funds Division of the Department of Audit and all functions related to that division shall be transferred to the legislature not later than July 1 of 2027. Subsection B, the Director of the Department of Audit and the Director of the Legislative Service Office shall jointly prepare a plan for a Type 2 transfer under statute. Again, that's that governmental reorganization process that's in statute. A Type 2 transfer is essentially just the transferring of one program between agencies. It's a little different here because generally that's, transferring from one executive agency to another executive agency. So it would be a little unique to transfer that from an executive agency to the legislature. And as you'll see in the staff comment, in general, it's also the two directors of the agencies that would be involved, or at least the transferring, or the agency that's being transferred to. In this case, there would essentially be a new agency to be created, some type of a legislative office of audit. And so the committee could consider, if that was the direction that you wanted to go, creating that office and hiring a director and having them conduct some of those duties. That didn't exactly match necessarily the initial request of the committee, so I didn't take that approach in this draft, but that's something that could be considered. So bottom of page 2, the reorganization plan shall maintain the current operation of the Department of Audit by continuing the operation of all other divisions other than the Public Funds Division. Require the legislature to perform all administrative functions currently performed by the Public Funds Division. And note there that the plan would include recommendations for the structure of a legislative office of audit or a similar entity that would be separate from the Legislative Service Office. The plan would identify statutory amendments, rule and procedural amendments, and other regulatory amendments necessary to accomplish the reorganization, and then provide for the transfer of all personnel, supplies, equipment from the Department of Audit to that newly created office. You'll see in the staff comment there, again, another consideration that would probably just need to be noted in this plan, but many of the employees of the Department of Audit are classified employees under the state personnel rules, and if there was a desire to change them to at-will employees under the legislature, they may need to be offered and accept additional compensation. And then finally, on page 4, the plan would need to identify any other issues relevant to the reorganization. In subsection C, the plan would be required to be submitted to the governor, management council, and this committee not later than July 1 of '26, and would also be made available to the public. Management council and this committee would be required to at least, or each hold at least one meeting regarding the plan, and then a draft legislation to implement the plan. And it would be the intent that any approved plan would be implemented, not later than July 1 of '27. And unless otherwise specified, there'd be no changes until that time. Section 2 just specifies that this bill would not affect any rules or anything else previously implemented by the Department of Audit. So that's the bill, essentially, Mr. Chairman. I'd take any questions.
Thank you. Questions from the committee? Representative Lean.
Thank you, Mr. Chairman. I'd like to go back to page 4 at the top there, where you're talking about the difference between at-will employees and state employees. You mentioned that it would need additional compensation for the change in classification. Could you walk me through why there would need to be additional compensation to change them from a state employee to an at-will employee?
So, Mr. Chairman, Representative Lean, so a classified employee would be essentially an employee that would have a contractual interest in their employment. And there are some employees in the state government that are classified employees. Pretty much all employees of LSO and many other state agencies are at-will employees, so they wouldn't have that same contractual interest in their continued employment. So to the extent there are those classified employees under a contract, to change that contract, you would need to offer them some kind of interest that they would need to accept in order to change their employment classification.
Yes, Senator Ide.
Thank you, Mr. Chairman. Yeah, real quick, that was classified employee. I still don't, I guess, understand that. What is the difference like in compensation? Do they not get state benefits, or how does that work? Thank you, Mr. Chairman.
Mr. Anderson.
So, Mr. Chairman, so that term would just mean any employee that is employed under a contract that's something different than an at-will employment. So maybe they can only be fired for cause or whatever under the terms of their contract. That's all that means. There are some of those employees in state government that do have those contractual type of positions. And so to the extent those did exist, we would just need to consider that to move them to be an at-will employee. And again, I think that's something that could be handled through this reorganization plan, and could find out how many of those there are and what the approach would be.
So in essence, it's consideration for that buyout of the contract. Yes, Representative Lean.
Thank you, Mr. Chairman. Could it be something as simple as an addendum to their contract, or a change in their contract, or a new contract that just replaces them under the LSO instead of under the Department of Audit?
Mr. Anderson.
So, yeah, Mr. Chairman, I mean, there'd be multiple ways to do it, but generally, you would need to offer some kind of additional interest to that person to change their contract. That's all that's saying. So you can't just kind of unilaterally change a contract to the extent these are contractual employees rather than at-will employees. So you would just need to take that into consideration.
Yes, follow up.
Thank you, Mr. Chairman. I guess I'm having a hard time connecting the pieces as to why, if they're doing the same job just under a different branch of government, we would need to offer additional compensation. Could you help me connect that puzzle piece?
So, Mr. Chairman, it wouldn't necessarily be to do the job, but to change that employee classification. So if you wanted to move them over as a classified employee under the legislature, then maybe there wouldn't need to be any change. So I think it would just to be if you wanted to if the plan were to want to change them to at-will employees consistent with other employees of the legislature, then that may need to be a consideration.
And I would imagine the idea of consistency under LSO for at-will would be a consideration to that.
Excuse me. Yeah, Mr. Chairman, and again, this would be essentially a new kind of legislative office separate from LSO, so it may not need to
Okay.
do that.
All right. Any other questions? Okay. Thank you very much. Is there anybody here from the agencies or the public that wishes to speak on this? Welcome, gentlemen.
Morning, Mr. Chairman, members of the committee, Justin Chavis, Director of the Department of Audit. I have with me Rich Cummings, he's our Public Funds Administrator. So I figured I'd start by giving some information, because the bill says all the people and all the functions from public funds, and so I figured I'd give the committee a rundown of what public funds does, because the scope of what public funds does is pretty massive. Really, you're talking the entirety of the Director of the Department of Audit statute is performed by public funds. So our other divisions are all found in other statutes, but the Director of the Department of Audit statute is done by public funds. So just a rundown of what that is. There's a number of administrative functions that we perform that are not audits. So for example, the largest one is our census process. And so I'll include a couple of things in the census process. So that includes receiving and reviewing preliminary budgets and final budgets of special districts. So we look at those, make sure they have all the required elements, make sure things make sense. If there's issues that need to be addressed, we reach out to those entities, try to get those issues resolved. Then you move into the actual census forms. And so that is every local government entity except school districts report their revenues, expenditures, cash and investments to us. So that's 900-ish entities that report all their financial information to us. Some of you, I think, have been out on our website and have seen those census forms for those entities. So those come in, we do the same thing. We review those for completeness, reasonableness. If we see issues, we reach out to those entities to try to get those issues resolved. And then as part of the census report, depending on their revenue and expenditure level, then they have to submit additional paperwork, which we also review. All of that is then taken, so that's statutorily required. Those entities have to submit that information to us. We review it as part of our statutory responsibility to oversee the finances of government entities in the state. We take that information and then we produce the cost of government report, which is also statutorily required. So if you look at that whole process, you're looking between 4,500 and 5,000 hours every year to do that function. The next kind of administrative function we have is public officer training. So statute charges us with determining minimum training requirements for public officers, and that's defined as anybody who has the primary responsibility for the accounts of the government entity, as well as the governing body of that entity. So we're tasked with determining minimum training requirements, approving other outfits that might offer training, making sure those meet our minimum training requirements, and then tracking all of that to make sure that those who are supposed to take that training actually do take that training. So that's kind of a continuous process, so that's kind of hard to give an estimate on what kind of hours that takes. But again, we do that as part of our responsibility to supervise the finances of the state. And then the next kind of administrative thing we do in the Public Funds Division is manage the statewide audit. So that's the financial statement audit of the state of Wyoming as a whole, as well as the federally required single audit. So every 4 years, we put out an RFP. We receive all of the proposals. We review those. We score those. We determine what CPA firm we're going to go with. And then throughout that 4-year process, we monitor the progress of those audits, and we also follow up with any agencies that have federal findings. If the federal cognizant agency needs or wants additional information, we're the ones that facilitate that process. So that's kind of administrative functions that we're responsible for before you even get to an audit process. Once we start talking about audits, there's a number of audits that we are required to do. So those include various trust fund audits, some random audits, like we're required to audit the brand inspection function of the Department of Agriculture. We're required to do performance measure audits of state agencies. So every state agency has to have performance measures that get reported every year in their annual report. Statute charges us with auditing the accuracy of those performance measures. And then we also have statute charges us with either doing the audit or coordinating audits to be done of all the A&I boards that exist within the state. And then the last audit function that we're required to do is the school finance audit function. So a statute requires that we audit the data that goes into the funding model for all of the school districts. Beyond required audits, then we have audits that are, I'll say, discretionary. So those generally fall under audits of towns and special districts. So municipalities are required to get a CPA audit every year. Towns are not, and most special districts are not. So that falls under our purview to audit, and we devote resources to that because if we don't do that, there is no independent financial oversight of those entities. And there are, when you look at towns and special districts that aren't subject to audit, you're looking at between 500 and 600 of those entities. So many of those entities, no one ever looks at if we're not able to do that. We do have the authority to do audits of basically any financial nature of any government entity. For example, in our audit plan for next year, we have some audits planned of state agencies, stuff like that. And then the last thing that we do on a discretionary basis is assist in fraud investigations. On an annual basis, we've usually got a few of those that we're participating in, usually at the request of law enforcement. And so that's kind of a rundown of everything that the Public Funds Division is responsible for. It's quite a bit. If you think about, the state's expenditures on a biennial basis, about $4 billion. There's about $6 or $7 billion flowing through local governments. So there's quite a bit there that we're responsible for. And so I wanted to give a rundown of that because the bill mentions the possibility of the legislature standing up its own performance audit function. If the idea is to have a robust performance audit function, this severely limits the amount of time and resources that's available to do that. This takes up a lot of time, which is why we historically haven't done, one of the reasons anyway, why we haven't done much in the way of performance audits is just when you do what's required, there's not a lot of excess time. So if the idea is for the legislative branch to do a bunch of performance audits, this stuff kind of hampers that, I'll say. And then just wanted to make some comments about audits in general and independence. And so independence is a cornerstone of audit. It goes hand in hand with objectivity and credibility. The idea being that if the audit organization is independent, then the conclusions can be more relied upon because the organization doesn't have a horse in the race, so to speak. As we're currently organized, I would say the Department of Audit is kind of in the sweet spot for independence. Statute has set us up in a manner that allows us to operate independently. We determine, statute lays out what we're responsible for, but then we as a department determine who to audit on a risk basis, and we're free to manage that and make conclusions as we see fit. One of the potential, I'll say, conflicts I see is, I had mentioned we do the school funding model audits. So the legislature is the one that controls what's in the model, how it's funded, what's funded. So it's a more independent situation for us to audit that than if you move that into the legislative branch. Now you control the funding model and you control the audit function of that funding model. That's a less independent setup than what currently exists, especially given that school finance is an area that has been historically litigated. There's less, or maybe I should say more reliability in the conclusions done by us currently not being under the control of the legislature that also controls the model that's being audited. And so, just some thoughts there in terms of, what's being audited versus what can be controlled through statute.
Representative Lean.
Thank you, Mr. Chairman. Thank you for coming today, Mr. Chavez. It's good to see you. I have a question about Chapter 10 in your public officer training, so I'm grateful that you mentioned it. In 91510A, it says that you have 1 year to complete the training for anybody that would be handling the public funds. And then I heard you testify that you don't have a total calculated hours as to the impact of that. If you aren't calculating how many hours it takes to monitor that training, how is that training currently being administered?
Director.
Mr. Chairman, Representative Lean. So we have currently an online version that has different modules that people can go to our website, they can do those modules, and then after they complete the modules, there's an exam to demonstrate that you actually went through that training. Then we also have a number of other entities who have submitted training plans to us. And so we have reviewed those and approved some of those. So then as any training is completed, they're required to send us their certificate of completion essentially, and then we track everybody who has completed a course.
Follow up.
Thank you for that. I would wonder, how many employees do you have that oversee public officer trainings?
Director.
Mr. Chairman, Representative Lean. So Rich can correct me if I'm wrong, but usually we have the state and local audit manager track that. So those certificates come into our division email address, and then those are then forwarded to our state and local audit manager.
Follow up.
Thank you, Mr. Chairman. In addition to that, when you're speaking about audits to municipalities and special districts, how many employees in your office are currently overseeing those?
Mr. Chairman, Representative Lean, so for audit, for municipalities, they're required to get a CPA audit every year, so we don't audit municipalities. For the special districts and the towns, there's 6 dedicated specifically to that, and then we have a supervising auditor position that is available if necessary.
Follow up.
Thank you, Mr. Chairman. Thank you for that. So I hear you say that you have 7 individuals that are currently overseeing special districts. How many audits a year are they currently performing?
Mr. Chairman, Representative Lean, I'd say probably we're looking at, over the past couple of years, I'd say between 5 and 10 a year.
Yes, follow up.
Thank you, Mr. Chairman. Thank you, Mr. Chavez. I know that I have a continuation of questions. My additional one would be, I heard you say that there's approximately 900 entities that send in census forms to you to be reviewed. How many employees are reviewing those census forms?
Mr. Chairman?
Yes, Director.
Representative Lean, those same 6. So so the Public Funds Division is separated into essentially 2 functions, the school finance audit function and then the state and local audit function. So the state and local audit function, those 6 people, and then the supervising auditor, so 7 depending on what that person's audit schedule looks like, handle everything public funds related that's not a school funding model audit.
Thank you very much.
Representative Rodriguez-Williams.
Thank you, Mr. Chairman. Director, I'm a little baffled about the administrative functions of your office and the outcomes of some of the audits. So essentially what they're doing is they're reviewing preliminary budgets, as you mentioned, in a sense being preventative, having some oversight of these special districts and how they're spending their money, perhaps annually or biannual. But then we have an audit of some of these districts where there's gaps or there's laws that aren't being followed, such as policies when it comes to investing. There seems to be some sort of disconnect between the preventative stage and then the outcome, which is the audit. I'm a little confused here, where the administrative functioning within your office is missing the mark. Because we should, if we're being preventative and providing this oversight, and this, we're holding their hands by reviewing budgets and making sure everybody's aligned with what they're supposed to be doing, but then we have radical outcomes in the audits. Why?
Mr. Chairman, Representative Rodriguez-Williams. So the census process, when we're looking at that, that's pretty high level. That is, those census forms come in and they're buckets of revenues or buckets of expenditures. And so that's a high level review. An audit is much more detailed. And that involves, for us to make the conclusions of an audit, that's a much more involved process where we're having to look at detailed information. That's not really stuff that we can determine from those census reports alone.
Follow up. Any other questions? Senator Vice Chair.
Thank you, Mr. Chairman. Thanks. So in the Public Funds Division, how many total FTEs are there?
Mr. Chairman, Senator Larson, 17.
Okay.
Follow-up?
Yes, thank you, Mr. Chairman. And you maybe already touched on this. The public officer training is kind of inside the 6. Is that kind of what I heard?
Mr. Chairman.
Yes.
Senator Larson, so for the updating of the training, or when we're requested to give the training, yes, that would be that 6. For tracking of who has completed it, that would be the audit manager over those 6.
Follow up, Mr. Chairman?
Yes.
Thank you. So in the beginning, you threw out some big numbers. We were 4,500 to 5,000 hours, and so we're kind of going, wow, that's a bunch of people. But if you figure they're 2,000 hours per year per person, that's only 3 people. So I just wanted to make sure we kind of got that out to not overwhelm us. That's probably not a question. Can you verify that?
So, Mr. Chairman, Senator Larson, so the census process doesn't run over the entire year. It runs over essentially the last 3 or 4 months. So it's more than 3 people for that section of time. The rest of the time, then we're trying to do audits or other administrative functions that we're required to do.
Mr. Chairman?
Yes, Senator.
Follow up. In the statutes of the creation, I guess, of the budget or the management committee, I think it goes into the management audit committee in 28.8.107. And it states that we're supposed to do these conduct audits, and I'm sure you've read it, but conduct audits of agencies which may include, like you said, program evaluation, performance audits, analysis of policy alternatives, audits of the accounts and operations of any agency or of any entity directly or indirectly receiving state funds. So that's kind of where this is all coming from, is we as legislators and the LSO office, we aren't doing these. And I think that's what all of us are saying, is we're not doing them. And so we need to do them. So that's where this is all coming from. And I don't know if I have a question there, but I think the whole idea is to bring that division over to us. But what do you see, maybe, I don't know, maybe conflicts or something? Do you have an idea on that, LSO, a division of that is doing these audits? And my idea is that we actually take it from the executive branch, but do you have comments on that?
Director?
Mr. Chairman, Senator Larson. So I think just backing up a little bit history-wise, so I think the program evaluation, when that function existed, that is similar to performance audits. So at one point in time, LSO did do that function. We did our function. We just made sure we didn't overlap. And then I would say, just going back to my independence discussion, that depending on what's being audited, I think there could be conflicts with a legislative audit function auditing something it also controls. Like I say, the school finance audit function, I think, is a more independent setup now through us than if it was done through the legislative side. Also controls the model, what's in it, how it's funded.
Yes. Vice Chairman.
Mr. Chairman, sorry. So that is one specific area that we could deal with, I would say, in the process. Is, say, anything that the legislature controls directly, I guess we do on most everything, but specifically on schools. Is that kind of what you would say we could do?
Director?
Mr. Chairman, Senator Larson, I'm not sure what question you're asking. Are you asking if there's other examples of where there might be, say for example, hot topic, property taxes. You have legislature cutting property taxes, saying, we think the government entities will be just fine without the revenue. And then you have government entities saying, it's gonna hurt our operations a lot. So say if there were to be an audit done on the impacts of property tax reduction, I think that would be another area where if we were to do that, that's going to be a more independent situation because we have no horse in that race as opposed to an audit function that's controlled by the legislature performing that audit. So I think there's a number of instances where you could have that situation.
So you mentioned, Director, the school finance function. Because the legislature does that in a block grant, I was trying to understand, you actually audit that in a modeling formula?
Mr. Chairman, yes. So the data that goes into that funding model formula, so ADM, transportation expenditures, special education expenditures, at-risk kids, we audit the data that goes into that.
So I don't see an independent kind of conflict because of the block grant application. It's not, those local entities can pretty much do what they want with the money that's given to them through the block grant. Would you agree?
Mr. Chairman, I don't think I would just because you do control what goes into it and we're auditing what goes into it.
Okay, thank you. Yes, Senator Ide.
Thank you, Mr. Chairman. Thank you, gentlemen, for being here. Just to follow up from Vice Chair Larson on the FTEs, is that 17 number, has that been pretty consistent over the last 10 years, 20 years? Just a little highlight there if you would let us know. Thank you.
Mr. Chairman, Senator Ide, so it has varied so when the school finance audit function was put into statute, those numbers went up. And then after a couple of years of doing that function, we said, hey, the number of people that you gave us isn't enough to do this, so then we were given more. So at one point, I think the division was 22, but through budget cuts over the last 8 years or so, it's down to 17.
Yes, Representative Lean.
Thank you, Mr. Chairman. I would like to know about the public officer training. Who informs you that somebody needs to be trained? Is there something via the Secretary of State's office or the county clerks? How do you know who is now the treasurer to, when you look at your flow chart that comes with your public officer training, Chapter 10 rules, how do you know who you need to be training?
Mr. Chairman, Representative Lean, I will defer to Public Funds Administrator for that detail.
Thank you, Mr. Chairman and Representative Lean. Really, it's a bit of a challenge to find out who needs training, and it's really left up to the entities directly to kind of govern themselves in that aspect. There are ways that we can check at times depending on how clear they are when they are submitting, say, their budgets. Okay, so like say a special district, because a special district has to submit their budget to us. On the budget form itself, it requests who are their board members. And so from that perspective, when a board member changes or whatever, we're able to tell from that sense. However, if a local government were to change their clerk, treasurer, or anybody in that realm, if they didn't inform us, we wouldn't know until we show up for an audit or something to that effect. So it's kind of like a hit and miss. It's not exact, so.
Yes,
Thank you, Mr. Chairman. My follow-up to that would be is how long are these certifications stored?
Mr. Chairman, Representative Lee, I was trying to make sure I addressed the chair first.
Go ahead.
Yeah, so the requirement is that when we come into audit, when we do the audit, they're required to present us their certificate if if we haven't received it. And so that would be part of it. And so they have to have it the whole time, or whoever it is that took the course. Anybody that we have trained who has been trained through our system, our own, we have those on file. And so we keep those. We just maintain a list of who has it, and we also have copies of those. We would probably follow the state archive system as to how long we'll maintain them. So.
Follow up. Representative Lean.
Thank you, Mr. Chairman. In Chapter 10, Section 6, it talks about maintenance of the documentation. I'm curious to know how many individuals use the affidavit under penalty of perjury versus the actual certification of completion.
Mr. Chairman, so the question, just to clarify the question, you're wanting to know how many people have done it through affidavit versus, okay. So I wouldn't have that number right offhand. And again, the affidavit, we use an affidavit only if they have taken a course in mass as a group in terms of that, and then they submit it to us in that aspect. There are situations where for lack of a better term, the outsourced courses, the courses where they've got, that's been approved through us, they're required to maintain all the documentation of their folks. That's actually one of the criterias that we look at to make sure that they're maintaining a history of those that have taken their courses, so.
Yes, Representative Locke.
Thank you, Mr. Chairman, and thank you, gentlemen. Question for you, just in terms of, can you just fairly quickly just summarize what is the process for you choosing the audits? What is the process you go through, and what are the feeds to that process in terms of from the legislature, from the executive? How much of that is governed by your independence of choosing these versus other feeds into the process? And maybe even a quick summary of where you could get input that would say, oh, we need to do this audit. I'm just kind of curious the overall, that entry point, what drives it, and who's got access to doing that, to assisting with that process. Thank you.
Director.
Mr. Chairman, Representative Locke. So we have a risk-based framework that we kind of feed in different variables. So time since their last audit, or if they've been audited, that goes into our risk framework. Our experience with the census process. So if we have entities that are consistently having issues with filing late or filing incomplete information, or information that just has to be corrected. So various factors like that go into our risk framework. So for example, entities that are required to have an annual audit, we eliminate those from our audit plan because they're already being looked at. And then in terms of outside sources, so really we determine our work. We don't get any direction from the governor's office. Occasionally we've had the legislature reach out and say, hey, we're interested in an audit of this, and so we've done that. Or if we get, say, citizen complaints, those complaints go into our risk framework to determine what audits we might do. Sure.
Thank you, Mr. Chairman, and sorry.
Mr. Chairman, I'd like to add something additionally. So with that being said, even though, say, a municipality is required to have a CPA audit, there are other factors that might draw our attention to a municipality depending on a concern expressed to us in terms of a complaint or something to that effect. So.
Yes, follow up.
Thank you, Mr. Chairman. And then based on your audits, and I'm just trying to understand the end-to-end process. So you have an audit that has issues, and what is what is the reporting then? Who do you report, hey, we've got issues, issue needs to be addressed here? Just walk briefly through the outcome and who gets that information, how that reporting works, just to make sure we kind of all see the big picture of this. Thank you.
Mr. Chairman, Representative Locke. So it starts with, after we've completed an audit, we have an exit conference with the entity. So that's usually their management and a representative from the governing body. Once the audit is complete, copies of the audit goes to those same people, the entity management, the governing body. We send a copy to Management Audit Committee, the governor's office, and the clerk's office of whatever county that entity is in.
Representative Rodriguez-Williams.
Thank you, Mr. Chairman, Director. Piggybacking on the concept of audit follow-up, you mentioned that there were approximately 6 employees monitoring anywhere from 900 to 1,000 taxpayer entities. With doing the math, that's like 160 plus, give or take, entities per an employee to monitor. Does your agency truly have enough manpower to engage in following up on these audits?
Director.
Mr. Chairman, Representative Rodriguez-Williams, no, we don't have nearly the number of people that we would need to really do what we would like. I would like to put every entity that falls under our purview on a regular rotation for audit, be able to follow up. We just don't have the number of people to do that. So that's why we do our risk-based, try to determine where those high risks are in order to follow up.
Follow up.
Thank you, Mr. Chairman. So, Director, tell me, we have some sample audits. We've been audits to this committee. Tell me what the record is in your office, and I know you haven't been there forever, but tell me what the record is for non-compliance, looking at number of years of non-compliance.
Director.
Mr. Chairman, Representative Rodriguez-Williams, so I would need some additional clarification. So non-compliance with census reporting, non-compliance with fixing audit findings.
Representative.
Thank you, Mr. Chairman. Director, I think the word used in your audit reports, you have different categories. I'm looking for non-compliance under the compliance section of audits. I know we have one sample of non-compliance, the compliance section of an audit.
Director.
Mr. Chairman, Representative Rodriguez-Williams, so I don't know that I could tell you that number right offhand. It's probably something we could track down, other than to say that it's fairly common for when we go in to do either another audit or do follow-up, that there are issues that go unresolved from audit to audit or audit to follow-up.
Follow up. Senator Ide.
Thank you, Mr. Chairman. Just another quick question. You mentioned the year, or you mentioned when the statute was made for the Department of Audit earlier. First question is, when was that? And the second question is, how did we deal with auditing prior to the Department of Audit? Thank you.
Director.
Mr. Chairman, Senator Ide. So the Department of Audit commenced operations July 1 of 1990. Prior to that, you had what is performed by our public funds division and our division of banking. That function was performed by the state examiner's office. And then the mineral audit function was performed by the state auditor's office. And then the excise division was performed by the Department of Revenue.
Follow up. Representative Lean.
Thank you, Mr. Chairman. Could you talk to us a little bit about your relationship with the Department of Revenue and if you're completing any audits for them if they're requesting them?
Director.
Mr. Chairman, Representative Lean, so our excise tax and our mineral audit divisions work similar to public funds. They do a risk basis, so they determine the audits that they do. The Department of Revenue may reach out, and so if they do that, we take a look at what they're asking, and then we determine whether or not we pursue that.
Yes, follow up.
Thank you. In the Department of Audit, what is your overall employment base? How many people work with you?
Mr. Chairman.
Yes, Director.
Representative Lean, the department has 103 positions.
Follow up. So, I think what we're dealing with originally was program audits. And obviously, they're not regularly getting done. I would say you don't have the manpower necessarily to do that. When we looked at it through LSO, we were faced with that same issue of we would have to ramp up either in employees or outside services, whether you were, say, independent or whether you fell under the legislature, same situation, you'd have to, in your mind, have a ramp up to do proper program audits?
Mr. Chairman, yes, there is more than enough audit work to go around for any entity that wants to do it. Like I say, between number of entities, number of dollars, types of audits, financial statement audit, compliance audit, performance audit, those are all different types of audits with different types of objectives. So there is no shortage of audit work to be done. Really on auditing the local government or auditing the government side, I could probably put my entire department to work and there'd still be more audit work available. There's a lot.
And just to follow up to that, so because we've got some testimony this afternoon with smaller towns and improvement service districts and things like that, I see this as a kind of a broader issue. As we continue to have smaller water districts, improvement service districts, those that receive public funds that come under auditing, would you see it as an easier solution if some of those were consolidated into either larger districts falling under counties, things like that? Would that help in the auditing process, or does that necessarily make a difference?
Mr. Chairman, I think that idea, particularly if you look at it from the accounting side, because that's where a lot of the issues reside, is being able to find people that have solid accounting knowledge and experience. I think consolidating particularly accounting functions together could be a very effective solution.
Thank you. Any other questions? Yes, Vice Chairman Larson.
Mr. Chairman, thank you. And I think you probably went over this already, the FTEs in the school section.
Mr. Chairman, Senator Larson, 5 auditors and an audit manager.
Okay, any other questions? All right, thank you very much. Appreciate it. Any other agency or public testimony? Hello, please identify yourself.
Yes, my name is Ross Schrickman, citizen living here in Casper, and I have some experience. I was a field auditor for the Commonwealth of Pennsylvania for 7 years. This is the first time I looked at the bill. I am toward favorability of the bill. it's been mentioned, the importance of auditing as an independent function. I would also suggest, and I've mentioned this at one of your other meetings, the cities, maybe they should also come under the direction of this Department of Audit. That would create more independence. It would also take that cost and responsibility off them. And I am very much in favor of regular audits. We're coming up with the budget session, so I'm not big on government spending more money, but I think there'd be a lot of bang for the buck if this department had more resources to do regular audits on some of these smaller towns as well as the special districts, and that would be my recommendation.
All right, questions? Thank you very much.
Thank you.
Mr. Chairman, Joey Carenti with Rural Wyoming Matters. Recognizing this is just a request to develop a plan, it's not an actual bill draft to codify how it's going to happen. I'm a little surprised the committee has as many questions as they do to the department, as we're still trying to find out what the actual issue. It feels like collectively we're trying to figure out what the problems are, but there's a draft here to request the development of a plan with some specificity, some focuses, and I'm almost worried that this isn't ready to be asked to be developed so focused on a single thing, but getting into the content, my first concern is it just looks like expansion of government. Granted, it's a department that exists. We may be just transferring where they exist, who they fall under, but there's concerns of things like if you create this new office or this new office is proposed to be created, you have things like the director, the administrative staff. I'm thinking about real estate. I know there's not any room in the Capitol, and I don't think we can create this new office and leave them in the footprint they're in. So what real estate are they going to occupy? What's going to be the cost of that? What is the build to suit maintenance, the IT requirements, security requirements, all the things that go along with anything that's going to happen for a new office, especially if it's not already in a building that the state owns and operates. The direction or the intent to shift this over or back over to the legislature gives me a little bit of concern. I think it was brought up, policing your own work. I think it needs to be done. I think it needs to be looked at. I don't know that the legislature is the proper branch. And I heard the separation of powers argument at the last meeting, but it's a big concern of mine that this is going to fall under the legislature. The legislature is going to make the laws and the appropriations and also manage this office in some sense. I think there needs to be an additional separation because the legislature is not in existence to enforce the law. The bottom line is the executive branch is made for that, and if there are issues and concerns that the legislature has legitimately, we call for hearings, we have conversations, and we amend current statute and show further intent instead of taking up that work as part of the legislative work itself. I have a feeling I'm going to be asked if I have any suggestions, and I do. Anywhere throughout the legislation or the proposed draft plan where it says, mentions legislature, LSO, and the Department of Audit, we should consider adding, or the Office of the State Auditor. I think that this can be executed if we're looking at having it fall under a different managerial structure to put it back in the hands of the state auditor, at least a plan for the legislature and then a subsequent plan to keep it in the executive branch under the state auditor. So that would be throughout to include that office or another elected office if the interest is to take it away from the chief executive's direct control. On page 3, line 12, whether my suggestion that the state auditor be included is taken up or not, possibly inserting some language, procedural amendments, comma, and or constitutional constraints. I don't know if there's a legitimate constitutional issue with either transferring this to the legislature's control or any other department or office on the executive side. And I would want to make sure that any report or plan that was developed included a real close look at what the functions in the Constitution for each of those branches, offices, and departments would be. And to add to the Romanet 4 on that page, line 16, to add the or state auditor, but also to furnish a full fiscal impact report for any plan or all plans made. Because like I said, this might look like just a lateral move of some personnel from one office to another office, one department, one branch to another. There's going to be cost incurred. And I think the people have the right to know exactly what those projected costs are going to be. Other than that, it's a request to develop a plan. I don't know if I can be against that. I would just hope that maybe the scope or the people included in that plan or multiple plan drafts could maybe be expanded. And also a contemplation of if this did fall under the legislature or this new office is developed, is there a specifically if it's under the legislature, what committee would they be reporting to? Is it going to be this committee? Is it going to be political subdivisions? There's a lot of different players in the game because we don't have a specific audit committee for the types of audits we're talking about unless it is determined to be this. I mean, so just a few things I didn't see specifically outlined in the request for the plan that I'd be interested in hearing discussed or included. And with that, I'll stand for any questions.
Any questions? Representative Lean? Oh, I'm sorry. Senator Ide.
Yeah, thank you, Mr. Chairman. Yeah, just real quick, thank you, Mr. Corrente. I agree with you wholeheartedly on, trying to limit the growth of the size and scope of government. I don't know if this bill grows it or not. I think one of the things that we always need to be mindful of is less agencies to audit so we can shrink the Department of Audit as well. So thank you, Mr. Chairman.
Any other questions? All right, thank you. Good mid-morning. Don't tell her.
Good afternoon, Mr. Chairman, members of the committee. My name is Ashley Harpstreet. I'm the Executive Director for Wyoming Association of Municipalities. I just blew into Casper, so I'm so glad I got here just in time to offer some comment on this very important topic. Wyoming Association of Municipalities, part of our mission is to provide education and training for our 99 members. And one of the things we are providing is that fiscal officer training. We maintain those records, make sure that as we have new council members or new clerks or treasurers that are coming on, making sure that they are completing that training. We were very instrumental in that legislation that happened with looking at special districts in 2015. I think Chairman Knapp, you probably remember that task force. I think there's a lot left on the table that task force worked on that I think would help with transparency and maybe getting at what you're trying to get at with some of this legislation. But I just wanted to let you know that we're here as a tool. We are working with the Department of Audit, and this is all new, just so everybody knows, in the last 18 months since I've taken over as director, making sure we maintain that transparency and provide that assistance to our membership as part of our association. But with the Department of Audit, anyone that is coming in compliant, we're making sure that they have the tools and resources. Just knowing that 99 of the municipalities, 19 that the Director of Audit was talking about that are the municipalities, those are first-class cities, and those are the ones that absolutely have to have the third-party audit, okay? So 80 of them are towns that are on that rotation, and some of them, to be quite frank, don't know what they don't know. Half of my members are under a population of 1,000. And so with that, to try to be proactive and not be back in front of your committee again, we are standing up a municipal finance division that will be accessible to all of our members, especially those little guys, to make sure they have the tools. Because in our small towns, as much as we love them, we know sometimes resources are small. and there's not as many people with that skills. I know the director of audit could probably speak to the shortage of CPAs, not only in our state, but as a nation, we're facing that issue. I sit on the College of Business Advisory Board. I know accounting is a huge deal that University of Wyoming's been trying to push towards to get more CPAs. So having just auditors in general is just a hard thing. So whatever we can do to pool our resources and work collaboratively and collectively with the state and the legislature and the Department of Audit to help anyone that might be facing some problematic issues, we are here for you. So more of just a comment, just an update of how we're addressing this problem with you and seeking to provide that transparency. With that, I'd stand for questions.
Representative Lean.
Thank you, Mr. Chairman. I'm grateful that you came today. Thank you. It's nice to see you. I asked earlier a question about how many people are holding these certificates and how many people are coming in under Section 6 using an affidavit saying they understand how to handle the monies. Do you happen to know some of those numbers?
Director.
Mr. Chairman, Representative Lean, I was asking my other director that works over that program on the way up. I don't have those with me, but I will certainly get that information of what we have on record. Yep.
I just have a question. So are you doing that as a piece of the membership, or are you doing that as a contract for service?
Mr. Chairman, absolutely. That's part of their benefit of being a member of Wyoming Association of Municipalities.
Okay, other questions? All right, thank you, Ashley.
Thank you.
Any other public comment from the room? Any online?
Mr. Chairman, we have Mr. Lewis and Ms. Bextel online.
Okay, would you let them in, please? We'll start with Mr. Lewis.
Mr. Chairman, my name is Kevin Lewis. I'm in Laramie County. I reside in Laramie County. I'd like to address some of the comments made by the director. First off, the legislature has the power to control audit in Article 4, Section 14 of our Constitution. I would highly recommend that you take power over that provision and provide far more audits. We see all the time in the Department of Audit many findings that trouble us, and there are many holes in our auditing functions. The schools were brought up. The department audits the flow of data and the quality of data that flows from the districts to the Department of Education. But who does a program audit in a school? Who does a program audit in districts that are really well below average? Would it help the recalibration committee to know what those schools look like financially and educationally? The Superintendent of Public Instruction and the State Board of Education will do accreditation visits, but there's no auditor to go with them to see the money applied to the education. This may seem like a conflict, and certainly the director mentioned conflicts with the legislature controlling the model and then auditing the districts. However, you have the same conflicts in the executive branch. The governor spends the appropriations. The legislature should be able to see the receipts of those expenditures and how they actually get done. So if you wanted to avoid the conflicts, you could amend Article 2, Section 1 of our Constitution and add a branch of audit. But otherwise, you will always have those conflicts existing. I would suggest that given some of the extraordinary audits that happen on some municipalities, we really do need a better audit function. And I hope that this bill would lead to a closer examination of audit by our legislature. I stand for questions.
Questions from the committee? All right, seeing none, thank you, Mr. Lewis. And we have, who is the other person?
It's me.
Oh, hi.
Rebecca
Mrs.
Bexton.
Bextel.
Yes. Thank you, Mr. Chairman and the committee. I'm not sure exactly which section I should have put this testimony in. I think it's appropriate here when we're talking about auditing. Over the past few months, I've listened to, my testimony today talks about the Wyoming Community Development Authority. I've recently heard Scott Halversland, who's the executive director of the WCDA, tell the Corporations Committee that the WCDA provides financial incentives that help developers build or rehabilitate housing to be rented to low-income families at affordable rates, and their federally funded programs help Wyoming's most economically vulnerable. But I wanted to give you an example of a real case in with the WCDA here in Teton County, and I do think that we need to have some serious oversight regarding the WCDA's programs. So what I learned is we basically built a 48-unit complex on the last remaining Teton County fairgrounds. They took 10% of the remaining fairgrounds. And who is now being housed as supposedly Wyoming's most economically vulnerable are some of the wealthiest companies in America's employees. So we have Jeff Bezos' Whole Foods employees. They made $20.01 billion last year. United Airlines, for the Four Seasons, UPS, Avis, and Budget Rental Car. And I also wanted to address, I had asked Mrs. Kathy Swanson, who is the head legal for the WCDA, at a public record requested what the developers and managers got paid. And she directly told me that she is not in possession of that information. I was able to chase it down another way, and I've seen their signatures on these documents, so she was just being dishonest. But basically what we've had is we had a private Montana developer. They only put $100 into the project. I'm not exaggerating with that. They put $100 in. They got $1 million from the town, $1.25 million from the state through the ARPA funds, over $2.5 million from the WCDA, and nearly $14 million in federal tax credits. And with only $100, they've ended up privately owning a $23 million building on public land. They don't pay any property tax. The WCDA works hand in glove with the Department of Revenue to get these major out-of-state companies either full exemptions like they do in Natrona County and Teton County, or reductions. And so the WCDA, we had 10,000 emails and 2,500 locals sign a petition to stop this project. We hear a lot about local control. I personally informed the WCDA of what was happening here and how this project was not the will of the people, and they just railroaded it through anyway. Thanks to Secretary Chuck Gray, who called for an investigation of this WCDA project, I was able to get
Mr.
my,
Chairman, point of order.
okay.
I'm not sure.
What is your point?
I'm not sure if we're on the topic of this actual bill, so I would question that. I'm sorry.
Okay, I wasn't sure. I think I was supposed to talk at the 11 o'clock time, but they just, I just got kind of stuck in here. I can come back or whatever, or wrap up my thoughts.
Yeah, I think you may be looking at the next.
Segment, okay,
topic
that's
item.
fine. That's fine.
So, all right, thank you.
So am I just hanging out here for the rest of the presentation and then coming back?
You can hang out if you'd like to.
Okay, thank you very much. Thank you.
We do have one other person online.
Mr. Chairman, he was just sent the link, so if he can quickly log on, we can get him on.
Okay. Oh, that's all right. We are going over a little bit. Can you hear us? Are you on?
Mr. Chairman, they're still trying to register to get on.
Okay. I can feel his presence, but we're not quite there.
Mr. Chairman, Mr. Pepper is on now.
All right, welcome. Please introduce yourself and we'll receive your comments.
Good morning. Thank you, Mr. Chairman. Mark Pepper, Executive Director of the Wyoming Association of Rural Water Systems. As with WAM.
Chairman, Mr. Pepper is on now.
All right, welcome. Please introduce yourself and we'll receive your comments.
Okay. Good morning.
Mr. Chairman.
Mark Pepper,
Executive Director of the Wyoming Association of Rural Water Systems. As with WAM. Let's see, are you watching us on YouTube?
No, I just got off.
Okay, thanks.
Thank you, Mr. Chairman. Mark Pepper, Wyoming Association of Rural Water Systems Executive Director. I wanted to weigh in just a hair, as with WAM. All 99 communities are members of our association, as are 220 special districts that own and operate water and wastewater systems in the state of Wyoming. We assist all 320 plus with financial and budgeting assistance. I think one of the things, and this has been a topic of discussion ever since I joined Rural Water in 2006. I've testified in front of corporations, I think 5 times on this topic of strengthening the audit function or the oversight function. I don't know if we need to move the entire Department of Audit. I'll leave that up to you guys as far as some of the other activities, but public funds, I think it's more looking at the Municipal Fiscal Procedures Act and possibly looking at how we strengthen some of that. As one of the other panelists or others noted, there's very few Class A cities that are required to be audited. Under federal audit requirements, any municipality or special district that receives in excess of $750,000 of revenue, and that could be through grants or loans for infrastructure projects or whatnot, are required to be audited until that project is completed. That becomes a big expense at times. Single audits right now, a governmental audit that's required through a CPA firm, typically are somewhere between $20,000 and $25,000. So you may have a special district with $100,000 in revenue, and now they get a $700,000 or $800,000 loan grant to put in a new water tower or other infrastructure. And now they're incurring a $25,000 cost to be audited as well. The things that we could do, I think, in the MFPA specifically is getting more accounting firms. Yes, there's not as many CPA firms that do governmental audits anymore due to the liability factors, but there are still plenty of CPAs around or high-level bookkeeping firms that I think could be utilized in doing what's called agreed-upon procedures, and could be going in and looking at a special district or a community's financial records on a limited basis, just kind of making sure that the bank recs are done, making sure that the information in their financial statements transfer from their financial statements to the F-32 or the F-66s and filed with the Department of Audit. I think that would go a long way instead of, I've never been a fan of some of the other MFPA requirements that allow for self-audits, that allow for quote, quote, independent third-party audits. Sometimes that third-party audit is done by a neighboring community. And so the clerk in one community goes over and does the audit of the other clerk and vice versa, as opposed to independent third party. And also keeping in mind that if we utilize CPA firms, they are licensed. Their license is at risk in some of these cases. They're not in the business of finding fraud. If they find fraud, they investigate. But I think just the additional strength of that scenario would certainly help in the oversight of certainly in the public funds area. And I would stand for any questions.
Thank you. Questions? All right. Thank you for your testimony.
Thank you.
Appreciate it. All right. Any other persons online?
Mr. Chairman, that's everyone on Zoom.
All right. I will close public testimony. What is the pleasure of the committee?
Move the bill.
It's been moved by Vice Chairman Larson, seconded by Representative Lean. Any amendments? All right. Any comments on the bill? Representative Sherwood.
Thank you, Mr. Chairman. I think at this point, I'm against the bill, and I'm more interested in looking at it as an interim topic next year, just because we're so far away from where we started. So our approved interim topic was an evaluation of executive branch agencies' programs and thinking about what was no longer effective, what we could take off the books, how we could streamline our executive branch agencies by eliminating sort of inefficiencies. And now here we are talking about a complete reorganization of the Department of Audit. So for me, it's just too big of a jump. And the fact this is our third meeting and we're just now seeing this bill draft, I don't think it's providing us enough time to vet what the unintended consequences may be. And yes, it is just a plan, but it does feel like we're growing government without fully understanding the scope of what the public functions are. So I'm going to be a no.
Thank you, Representative. Any other comments? Representative Lean.
Thank you, Mr. Chairman. I just would like the record to reflect that we're doing 5 to 10 audits a year on roughly 900 census reports that are coming in, and that is insufficient when it comes to auditing state government roles with tax dollars. When taxes are paid, we have an obligation to our citizens in the state of Wyoming to make sure that they are transparent and being spent appropriately on government functions. And with that, I would like to move forward with the bill to make sure that we are providing an adequate role for auditing of the dollars that are being allocated around the state.
Any other comments? I just have one. I think that it's not a knee-jerk reaction. I think that, number one, we're responsible for these audits. They're not happening. And we've tried to come up with several different options, from LSO to offering to take that on, going to third party, going to adding employees. And I think this is just one other plan going forward that we can look at and judge through session. So I'm going to be in favor of it. Yes, Vice Chairman Larson.
Mr. Chairman, thank you. I too agree with you on that. I don't think the legislature is doing what is stated in the statutes, especially this committee. I reiterate 28.8107. It is the responsibility of Management Audit Committee to audit the accounts and operations of any agency or entity directly or indirectly receiving state funds. And I think it's our responsibility, and we shouldn't be giving that away to the executive branch. So I'll be in favor.
All right, any other comments? All right, could you please poll the board on, I'll let you state the bill draft.
This is a roll call vote for Bill Draft 26 LSO-0165, Legislature Reorganization of Department of Audit. Senator Dockstetter. Senator Ide.
Aye.
Senator McEwen excused. Senator Olson. Aye. Senator Rothfuss excused. Representative Lean.
Aye.
Representative Locke. Representative Rodriguez-Williams.
Aye.
Representative Sherwood.
No.
Vice Chair Larson.
Aye.
Chairman Knapp.
Aye.
Mr. Chairman, you have 8 ayes, 1 no, 2 excused.
All right, that bill moves forward. Next up, we have the Wyoming Business Council. I apologize, we've cut into your time a little bit, but here we go.
Thank you, Mr. Chairman. Members of the committee, thank you all for entertaining us today. And with me, my name is Josh Durrell. I'm the CEO of the Wyoming Business Council. And with me today, I have Sarah Fitzgerald, who's our Chief Strategy Officer, and Ron Goldberg, who is our Strategic Partners Director. And we saw your request for information. We've provided a document and a presentation along those lines. If you'd like, I can walk through the presentation, if that would be helpful for you. I believe the folks at LSO have that information and could display it on the screen if necessary. Otherwise, I do believe that we did provide that. So would that be possible?
All right, Chief Durrell, yes.
There we go. Okay, we'll go ahead and go to the next slide. I think more than anything, one of the things that we looked at when we contemplated this request and what we would like to show with all of you is perhaps the difference in the way that effectiveness and efficiency work together. And I think efficiency is if possible, maybe jump to that next slide. I apologize for not making that clear.
Just one moment, Mr. Chairman.
There we go.
Thank you. So we looked at both elements of this. I think doing the right things is probably paramount for the Wyoming Business Council, because I think we have a sort of a methodology that helps us iterate to do the right things. And then efficiency is doing things right. And I think once you find those right things, it's a matter of making sure that you cut any waste out that you can to do those things right. So we'll go ahead and jump to the next slide if possible. Thank you. This is that approach that I mentioned. We take an iterative approach to this because what we see is our economy is really a complex problem. And while I would love for there to be a silver bullet or a simple answer to our economic challenges, there really aren't. There are a lot of different ways to solve them and a lot of different things that we need to work on. So we utilize what we call the economic growth flywheel as our methodology. And essentially, this means that we are continually working on improving. And I think this is what you might think of in manufacturing as a continuous improvement process. And you might think of as a way to continue to, one, understand the problem, which in our case is very complex and sort of hidden, and a way for us to get better by building the muscles for that solving that problem. And so I won't bore you with the details of this, just know that we will likely not look the same in a few years when or maybe even a few months if we're back in front of this committee. We will continue to evolve and utilize this methodology to better solve the problem that we're being asked to solve, which ultimately is economic decline in Wyoming. And so if we jump to you could actually skip that slide. I just said that we're in economic decline. So if we jump again, we can take a look at the real GDP per capita of Wyoming. The rest of the nation's in gray, Wyoming is in orange, and our neighboring states are in blue on this graph. And even if you were to take out 2008, which was a pretty good spike. I think that was a natural gas. There was a lot of natural gas exploration and selling there that went on, and pricing was good. And so our GDP was very, very high. Even if you took that out, we remain relatively flat versus our peers and versus the rest of the country. And I think in terms of what we want to do is provide growth for our economy, and flat is not acceptable to us. If we jump to the next slide, you'll look, because it turns out that if you were to go out and ask folks what the GDP is for your state, or gross state product, for example, people would sort of say, well, I don't know. And they might say, I don't feel GDP. And so what we want to do is help people understand what that means. And so if you look at some of the markers that are below the surface of GDP, you're going to see that our employment is flat, that our wages are actually shrinking. So our employment is toward the bottom of that curve on the left. You'll notice Wyoming is above a few states. One of note is Mississippi, who's at the bottom of the pile there. And then if you look on the graph on the right, we're the bar in red, and our median wage is shrinking. We would again much rather be where our wages are rising and not shrinking, because again, as you talk to people on the street, they're going to say, well, are there more opportunities or are there less? Are there good opportunities where I have the ability to, deal with cost of living, deal with housing, deal with those kinds of things? Or am I going backwards? And I think people don't want to do that. If we jump to the next slide, you'll see a couple other indicators that to us indicate that we're in economic decline. The population is increasing. However, our workforce is it's either shrinking or flat, depending on how you want to look at it. It is not ideal. And the gap between our population and our workforce is increasing. When we take a deeper dive into the demographics of our state, the demographic band from 65 and above is the area that's growing, while those the other bands of younger folks is not. And that is probably most starkly demonstrated on the curve on the right. The curve on the right indicates the outmigration of people who are born in a state and where they go next. And so what you'll notice is that we are the top line in that. We are the blue line on that graph. And young people in the state of Wyoming leave at a rate that's 2 times the national average. And generally speaking, they do not come back. That boomerang it's what we might consider a statistical anomaly when it happens. We all know somebody who's come back, but we don't know enough to sort of fill that gap. And that's a challenge for us, because not only is that the persistent challenge of what we've all heard of as brain drain, that is not just brains. Those are people we know. Those are family members of ours. Those are our children. Those are our friends and colleagues that need to leave the state to chase opportunity. Our agency is really designed and charged with changing that. And so when we look at economic decline, we say, how can we fix that? So we look at that as, how do we improve our effectiveness? We could do things faster, cheaper, better. However, if we're not effective, there's not a whole lot of sense in being efficient. So as we look at this, I do want to, we tend to focus a lot on Wyoming. There's no doubt about it. We really look deeply at the challenges that are in Wyoming because, one, that's our charge. But I think it's also important for folks to realize that this problem that we experience in Wyoming is incredibly acute to Wyoming because we are so rural. In other places in the country, rural communities are facing a very similar challenge. However, they tend to have a population center that's close enough to where they can sort of create an economy between them and that larger population center. If we jump to the next slide, slide 9 demonstrates the cycle that we experience. And I think it's important to understand this because it's going to frame up the elements that you've asked about, and it's going to help understand why we've made some changes, why we do what we've done, and why we will continue to use that economic growth flywheel. The cycle in rural communities is that there are just not enough workers. When we talk to businesses in our communities, they say, yeah, we would love to expand. We would love to be able to grow. One of our biggest constraints is workforce. And we know that. We all that have been in business know that that's a challenge. That is a really, really big challenge for us. And so what happens is that those businesses either stay the exact same size, or in some cases they leave to be able to attract the workforce that they need, or they set up a second operation in a place that has more population. And what ends up happening is that the number of jobs decrease. Well, we all know that when a layoff happens, I happen to come from Carbon County, and I grew up in Rollins where my dad was a coal miner. Well, there were times when those coal mines laid people off. We happened to stay in Rollins and in Wyoming because we loved it here. However, a lot of my friends, they left school. When those mines shut down, they all left, they moved away. So we know that that occurs. And so that cycle continues because it turns out that once those workers leave, because there is no other way for them to stay, they're now out of the workforce. And again, that means that problem is now exacerbated. And that spiral is not a good one, okay? Now, the challenge for us all is that there's a virtuous cycle in cities. So, and we have the data to show where people move to, and they move predominantly to populated areas, very populated areas. And so there are lots of workers, therefore businesses can grow and thrive and start. The jobs increase, that means the workforce increases. They attract those 2 out of 3 people from our state. And so that virtuous cycle is a challenge that we're trying to overcome. And so I hopefully this helps sort of frame that understanding of the problem that we're working on so that we can build programs and work with you to look at our programs and be critical of them so that they solve that problem, not so that they're super efficient at doing what they do, but they're effective at the bigger problem that we see in Wyoming. If we can jump 2 slides. There's a break slide there. And maybe I'll pause there for just a minute and make sure that if there's anything I missed or I glossed over, if folks have a question, I'd be happy to answer it.
Any questions from the board? From the committee? Nope.
Thank you.
Okay, keep going.
Thank you, sir. So as we look at this, one of the things that we were really critical of ourselves. So I don't know how much historical context you have. The Business Council's been around for about 26 years. There was a period of time up through that time where I think we did a lot of things all over the state, and I've heard various different ways of describing it. They involve peanut butter and fairy dust and things like that. And what I would say is that I do really love peanut butter, but it belongs on a sandwich, not on as an economic development practice. And I really think that what we started to do is say, what programs do we have that are effective? And if they're not effective at changing economic decline, let's get rid of them. Let's really look, what problem do they solve? Are they solving it? Could they be efficient? Could they be effective? And then we started to cut programs and started to say no to projects that came before us. Well, I can tell you this much, when you cut programs, it upsets 1 or 2 people, it may, but when it comes right down to it, we had to have that spine to say, no, we're going to be strong enough to cut programs. And so we cut a number of programs, or we transitioned programs out of our charge to an agency that it might be more appropriate for. In doing that, of course, there's change. There are things that you've got to work through. No doubt change management is part of the deal. But what we found is that we could then focus on the real challenge that was ahead of us. And the real challenge that the legislature and the governor and the governor's previous really wanted us to work on, but we'd sort of spread ourselves thin and really, whether it was peanut butter or fairy dust, we sort of were doing a little too much and we were doing too little in all of those places. And so we put together this list just so you could see the elements that we have either transitioned to other places or things that we've stopped. Again, what I will tell you is that these are the notable things. There are a number of programs that we still have at the Business Council, but they look nothing like they did 5 years ago. They have all continued to, because we take that iterative approach, and they will continue to change to match the problem we have and to increase its effectiveness. If we don't mind, maybe jump to the next slide. But I would say that the headline grabber of all programs that we have is Business Ready Communities. I think that is the most known and frankly most unknown program in the state. Now, it happens to be the one I know the most, so maybe maybe it's a bit of a hyperbole, but the bottom line is that BRC is definitely gets headlines, but the inner workings of it are probably not known very well by many people. Shame on us for not making it a little easier. We'll continue to work on that, but it's a challenging thing. It essentially is an infrastructure program that helps our communities build infrastructure for growth. I want to add that preposition because in our estimation, we want to invest in places that have the opportunity to grow and have the potential to grow, because ultimately we're working to reverse economic decline, which means that we'll need to grow. If we jump to the next slide, this is a nice little graphic that sort of helps people understand where the money flows. And this drawing, which started out on a whiteboard for me as I was working to understand this program back in February of 2020, really helped me understand a misconception that I had. I as somebody who was in the private sector and didn't know much about the Wyoming state government, as I was approaching this particular role, I tried to understand what BRC did. And I had some involvement at a local level with some of the projects that were going on. And I miscorrectly or incorrectly thought that the program gave money to businesses, and it does not. The program provides infrastructure, and it's generally speaking, it's assets that the community owns that are things like water lines or sewer lines or curb and gutter and sidewalk and things that are needed for growth. But that goes to the community, and that is an asset that's built at the community. The arrows that go into the community, you'll see that come to the state and to the community, those are where the arrows are, right? Like that's how it works. And so that asset is utilized by a business or by a growth so that it can be, so that community can grow. However, it does not deliver money to a business. And it, again, that's just not part of that program. All of the money and the assets go to the community and then come back to the state. If we jump to the next slide, I want to alert you to a really big number that is that's a little bit challenging for us. I tend to like to focus on the places where things don't work more than the places where things do, I think, just because that's the biggest opportunity for improvement. And for us, we look at the $416 million that were utilized between 2004, when the Business Ready Communities program was started, and to 2019. In that 15, 16-year period, about $400 million were put out into the communities. And I want to have you think about something. I want to say not much changed economically. However, I do want to help everyone understand that money is not wasted. That money is continuing to be utilized in our communities as assets in the communities that our communities own. So it is not money that went to businesses. It is not money that isn't still very valuable and useful in those communities. However, it did not change the economic decline that we're facing. And I think that for us, again, we could be very efficient with getting grants out to communities for water lines and sewer and other projects, but is it effective? And this is the question that we asked ourselves, because in my estimation, my job is not to be better at getting money out to communities or faster. Our job is to make sure that it does its job. And so the first question we asked, if we jump to the next slide, is, well, I will say I think the legislature called for it, and I know that Governor Gordon called for taking a business approach to the Wyoming Business Council. And so in 2020, we started to take a really hard look at projects, and we said no, because we were looking to produce a positive ROI for the state, which makes sense, right? Like we should be providing a return with our investment. If we jump to the next slide, what we found is that we could do that. So if you look at the period, the 4-year period before that, or excuse me, the 4-year period before that and the 4-year period from 2020 to 2023, you can see that the investments that we made actually went down. We made fewer investments. We leveraged almost 4 times the money. We had more jobs created at a much higher wage. The local economic development revenue went up. That means that the money that stayed in the community for economic development purposes went up, and the state revenue recapture also went up. All positive markers. We could sort of pat ourselves on the back and say, we got it, we figured it out. But what I can tell you is that what we actually determined, and those graphs show at the beginning, it's not enough. We could do this all day long, and it's still not going to change the outlook of Wyoming's economy. Again, I know that I'm not painting a great picture for the 3 of us up here. You're probably wondering, well, what the heck are you all doing? Well, I'll tell you, what we're doing is we're continuing to be critical of ourselves so that we can work on the big problem, which is economic decline. And doing projects with a positive ROI, should we do that? Absolutely. Is it enough? No. So if we jump to the next slide, we said, okay, well, there's another hypothesis in the growth, economic growth flywheel. Let's take another look at it, and let's see if we can build local capacity. I know that all of you are likely big fans of local control. I am. I feel that economic development, just like government, should be closest to the people that are affected, and they should have the power to do those things on their own. What that means in some ways is that we should work ourselves out of BRC. Right? Like, it would be a beautiful day if the BRC budget was 0 and all of our local economies could build these things on their own with their own revenue. I would love that. Nothing more would make me happier. We could do economic analysis. We would still have a role to play, I think, in looking at the big things. But local control to us makes a lot of sense. So we said, well, what if we could use BRC to build local capacity? What if we could make it so that when we did a project, it actually kicked off revenue that could be used for economic development, so we wouldn't have to go back again? And we have plenty of examples where that happens. If we jump to the next slide, thank you. There's an example really close to home here. In Mills, there's an example where, again, a community asset is being built that a local company will lease from that community. They will pay the community to utilize that asset, and then the state will then benefit as well as the community for economic development. We love this model. It's a beautiful model. It's closer to where we want to be. However, what we found is that it takes too long to generate that local capacity, and there just aren't enough cycles to build the know-how. I think all of us can think about our own jobs and think the first time you do something, let's take, I don't know, I've tiled a bathroom or 2 in my life, and let me just say that the first one I did, I learned a lot. The second one I did, I got a little bit better. The third one I did looked really good. The problem is that I did the first one at my house, and all my friends benefited from that know-how, right? And it's the same kind of thing with economic development. We have that exact same situation where a community will do this. They'll do it once. People change, the know-how gets lost, and the money doesn't come to the community immediately. It takes time to build that. And so what we found is that it's probably too little too late. And so we said, gosh, what could that be? And how do we do that? If we jump to the next slide, what we found is that building local capacity is not fast enough, and it's not enough to break that cycle of decline that our local economies feel. So that led us to continue to find out how to be more effective. I'm going to gloss over this a little bit so we can get to questions. I know that all of you have some questions about the data that we provided, but I want you to take a look at this. And what I want to help everyone understand is that at every board meeting that we do and every project that we look at, the bar is raised. We have done projects that even in the last 5 years, we may not do today. Now, to some, they'd be like, well, gosh, you funded it in the past, you have to fund it in the future. And we say, no, that's actually not true. We will continue to raise the bar. And at each of these projects and each of the situations that I highlight in these program milestones, those are elements where we are either changing the scrutiny of our board. We are changing the rules that we are utilizing for BRC because we get to control the rulemaking authority. In fact, we just had a rule change that is hopefully going to go into effect here in the next few weeks that will make it even tougher to utilize BRC. And you say, well, gosh, is that, how efficient is that? Well, it's actually effective because what we want to do is we want to make sure that the local communities can bring more to the table and have more skin in the game. Those rule changes are not popular when we make things tougher, but they're the right thing to do. And I think if you look at these milestones and if you talk with the communities that work with us, we continue to raise the bar and they continue to respond. And I think that there's a really important message there. When we raise the bar, people aren't left out, people's capacity grows. We're testing the limits with this next rule change. There's no doubt about it. But I believe in our communities, I believe that they will actually raise to that level. There are just a couple slides on that. We could jump to slide 22. Again, mostly just an example of the amount of change that we have incurred over the last few years. And then if we jump to 23, this gives a brief overview of the changes that are coming forth in the latest edition of the rules. Again, all in the spirit of changing the effectiveness of this program and building an economy that our local communities can thrive in and continue to be a part of. I think we can jump to the next item. These actually did not make it, but the proposed statute changes. One of the things that I think is really important for us is that we need a really solid and frankly an active relationship with the legislature to make some of the changes that we need. These are some of the basics that we need. These did not move forward through the Minerals Committee this particular interim. However, we want to continue to engage with the legislature because we would like to have the pace of change faster and more accurately reflect the problem that we have because that problem continues to evolve. So if we can continue to work with the legislature in the next interim and continue to work over time, we will likely have a number of changes that will make us more effective, and we'll continue to do so. If we jump to 26, we can jump into some of the things that I know that many of you were asking about with our programs. This slide demonstrates a couple of things that I think are important. One is our what I would call our approach to solving problems. We really like to only deal with chicken and egg problems, which to many people are what they would consider unsolvable. But for us, that's actually a good role for us to play, which is to put pressure on one side of that problem and see if we can change it. In the case of startup support, the startup landscape varies from idea to thriving business. And we have a number of programs and elements that you can utilize in there. Most of them are service, some of them are funding mechanisms. And so, but the whole intent is to really fix the chicken and egg problem that we heard, which is there isn't enough money in Wyoming to attract deal flow, and there isn't enough deal flow in Wyoming to attract capital. Well, guess what? That's a chicken and egg problem. We love those. So we said, well, what can we do to break that chicken and egg problem? We happen to find a federal program that can be utilized to do just that. We call it YVC. It uses the State Small Business Credit Initiative, which is a U.S. Treasury program to do that. The experiment that we are undertaking in this whole process is how do we figure out what the gaps are? And then if the private world is not going to solve that gap in Wyoming, then what could we do that's as small and surgical as possible from a state's perspective to either instigate the change and get out, or create a program that maybe at some point we talk about efficiency with because we know what it's supposed to do and it doesn't. But that's where we are with startup support. There's some more data inside your packets, the data packet. And then economic decline and how we're looking at reversing it. I think it's important to take all of these elements and work with all of them. So it would be nice if we had one program that worked pretty well and we just needed to work on efficiency, but we don't. We have a multifaceted challenge here. And it's going to take probably more than even this slide demonstrates, with activating industry, empowering local leaders, uniting leaders, eliminating barriers to growth, having the connectivity in our state to not just, and I say this, yes, of course, that's broadband, which you probably saw in our budget, but also, how do we connect people so that the know-how can be shared across those communities? And then, of course, generating local funds. And my favorite one is actually about reducing regulations. I think that there is a big opportunity. We're seeing it at a local level, and we're helping at a local level in some communities in Wyoming to get rid of regulations that are hindering growth, and they're just not necessary in most cases. There's actually one we were discussing with the community members last night in this particular community, and it should be an easy change. However, I think there's a real reticence to change, and so I think regulatory reform is something we should really think a lot about. If we jump to the next slide, well, now it's time to maybe dig into the document, but I hopefully with that introduction, you'll at least see how we approach problems, our methodology for doing so, and the fact that we're really looking to become better with each cycle we take, and questions that you've asked and the ways that you will engage with us will only make us better. So we're looking forward to hear more. So thank you, Mr. Chairman. I'm happy to stand for questions.
Okay, we're right up against lunch, and I know there's going to be some hangry questions coming out. So let's start with Representative Lean.
Thank you, Mr. Chairman. My first question would be, how many employees does the Wyoming Business Council have?
So the Wyoming Business Council right now has 40 employees. Oh, sorry, through the chairman.
Oh, sure.
Representative Lean, sorry.
Representative Rodriguez-Williams.
Thank you, Mr. Chairman. Mr. Durrell, your organization was on the agenda during our last meeting, which was July 9th. Why wasn't there representation there during our last meeting?
Mr. Durrell.
Mr. Chairman, Representative Rodriguez-Williams, I don't know. I did not know that we were on the agenda. We would have gladly come. We'll come again next time too. So if I apologize for not being here.
Senator Ide.
Thank you, Mr. Chairman. Thank you, Mr. Durrell, Goldberg, Mr. Goldberg, Ms. Fitzgerald. I've had a lot of conversations with you. You obviously know that I'm not a big fan of the Wyoming Business Council in particular. I mean, I think the role of government is to be a referee, make the rules, force the rules, not to be an active participant. This is all good information. To me, it's of no interest to myself. I don't think it's the role of government. I mean, it's a redistribution of wealth is effectively what it is. When you're taking that money from somebody, government, doesn't create wealth anywhere. It has to come from somebody else. And with that, you lose value from the people that are given that money to them. You lose freedom there. And, the role of our legislature is, and it should be, it was the cause of our nation, is liberty, not necessarily economic growth. I mean, we set the rules, we set the playing field. And, you mentioned that, it's going for infrastructure primarily, but, it just seems like it keeps growing. I mean, you look at a lot of these entities that it goes to, whether they're winners or losers. We shouldn't even be in that game, in my opinion. It's a little bit of a shell game, I think, with, making it look like it's going to the communities, but it's always directed toward a particular entity that's either coming to town or, the state's trying to buy their business. I think everything should be through organic growth in our state. So I appreciate you being here. I appreciate the well intentions of the Wyoming Business Council, but From my vantage point, it's just a redistribution of wealth, and we shouldn't be in the business of that for the private sector. Thank you.
Do you have comments to that?
Mr. Chairman, Senator Ide, first of all, thank you. You know, you've always said that, and you haven't wavered, and I appreciate it. I also appreciated the book on that you gave me from Von Missy's perspective, and we've actually taken a look at that a lot. And I do think that one of the areas that you and I probably agree on the most is on regulatory reform. And I think we should make the rules, but I think we should be really thoughtful about those. And I think that if we make rules that don't make sense, we should be okay with getting rid of them. And I think that you and I see eye to eye on that. And I just appreciate your honesty and the fact that you can look at me and say, look, I don't think you're doing the right stuff, but here's some other stuff that you could consider. I just always appreciate that interaction. So thank you, sir.
Senator Dockstader.
Mr. Durrell, is there somewhere we could get a list of the projects that we've assisted with and somehow what they've turned into in a community? I appreciate his concerns and my colleagues' concerns and what he's saying, but we ought to be able to track those records and see what's being done. I know that there are other states that will take projects if we don't. It's already exemplified just in the past month. Is there some way we can track this a little bit closer? And then on the concept of losing the youth, ironically, I think it was the governor's business forum I was at last week of sitting at a table with 3 youth coming out of the university. And I just quietly listened to their conversation. 2 of them were headed to the Front Range for their careers and their work because they didn't see a future in Wyoming. So it's a legitimate concern. And if we don't fix it, who does? Thank you.
Mr. Durrell.
Mr. Chairman and Senator Dockstader, yes, there is a way for you to see all of the projects that we have funded through the Business Ready Communities program. That is on our website, and we track those. Our current rules say that we track those for 5 years. We are now going to be tracking that for the life of any kind of financial mechanism for that. So our rule change will allow us to track that project for even longer. So we do the same type of auditing that you might imagine. We take a look at the number of jobs. We take a look at the wages that that those jobs pay. We take a look at, are they doing what they said they might do in this case, especially in the case of business committed projects. So yes, we do track that information and have that. Much of that is available on our website, and we're happy to continue to provide more to this committee. I think it's a good partnership that we should encourage. I appreciate you, one, kind of like taking a view of how younger people view Wyoming and what the opportunities they have in front of them. I do think it's something that I'm glad that you listen quietly and let them carry on, because I always have a hard time when I ask a question, people tend to give me an answer that they think I want rather than what's natural. So I appreciate that approach. And that's something that we're really concerned about, because in our estimation, we should be setting the policies and making investments that is going to make Wyoming attractive in 10, 20, 30 years, not those that are going to make us feel great in this moment. And that's a challenge that we face, because when we think about the young folks or those mid-career professionals who are having to make moves, we want them to make moves here in the state. We want them to have that opportunity. We also want the opportunity for folks to come back. And that's something that we're really focused on. So that long-term view is something that we're listening to the youth as well. Now, I will tell you, based on my limited knowledge of statistics, but a little bit, while that does confirm the overall numbers, I don't believe a sample of 3 is statistically significant. So, but I appreciate you listening nonetheless.
Thank you, Mr. Chairman.
All right, Representative Locke.
Thank you, Mr. Chairman, and thank you for the presentation. I really do appreciate it. But I want to focus a little bit, interesting, the Senator Ide's comment. If you look at your slide 19, for example, which is the Mills example, that's kind of a good example of, we threw $20 million in there, and if you add up those 2 numbers down below that, it doesn't look like a winner, right? It starts looking like that. Now, I throw that out there, and I want to understand kind of where does that go? Because I see you guys working on this piece of the economy. And so even if you do swing that needle in the plus, it's this size of our economy. You see what I'm saying? You're attacking this one little piece. And there's always been this confusion. Oh, we've got to diversify because the federal government's going to destroy our core industries, right? Diversifying this, trying to diversify this and grow this when our economy's here, are we putting our money in the right place? So it's obviously a slightly different question that's being asked over there, but it's got to be asked because we can still throw a lot of money at trying to move this little tiny needle. And what do we really gain? And one could argue, and you've probably heard me argue it before, is there's a culture issue sometimes where we get confused. We forget. If you look at our Wyoming seal, what's on there? Mining and oil and important things like that. And when we're swinging some of these little tiny pieces, are we really making? I mean, I would like to hear, you look at that 20 million versus whatever that is, 12 or 13 million dollar. Again, that's a loser, and you're trying to swing this little needle. Would love to hear your conversation on that.
Mr. Chairman?
Yes.
So Representative Locke, that's a fantastic question. And I think this is, for example, on slide 19, this is the hard dollars that come from a project. So that's money. However, the other element that this does not demonstrate is the economic benefit of those jobs. So if you look at what people pay in terms of sales taxes, the property taxes, those kinds of things, the ROI on this project it pays itself back in less than 5 years. So that's an investment in our community, in those jobs, so that we have opportunities for future generations of Wyomingites. Is that an investment that the government should make? I think that's a fair question. What I will tell you is that if I'm somebody who wants the economy to grow, I'll take that one all day long, because the revenue that comes back to the state that is not demonstrated on the slide, these are just hard dollars, is a positive ROI, absolutely. And so the other thing that I do want to mention, and I love the discussion of where is the government's role in this. Totally understand it. I definitely get it. It would be ideal if this was possible at a local level. If the local revenue or fiscal system allowed for a community to be able to do these kinds of things. For example, it's not this particular example, but a particular example in Evansville, again, just down the road, is a water line that unlocked industrial development so that things could develop here rather than on the Front Range where that company is headquartered, because they couldn't do it here before. So that's 250 engineering jobs, very highly paid, important for our current industries because they make natural gas gen sets that are utilized in the energy sector. It is definitely the types of businesses that we want, and their partners are then building out into that cluster. That unlocks growth. That's not going to get done by the private sector. They're not going to put in their own water line. They're going to go somewhere else. And the metaphor that I think about is, okay, imagine back in the days, everybody familiar with football, where back in the day, the forward pass was illegal, okay? So teams could only run the ball or make a lateral or a pitch back. And so then at some point, the rules of football changed and people could throw a pass forward. And I know that to many of us, we're like, what? That couldn't happen all the time? No, there was a time when you couldn't do that. And so I'm sure there were teams who held on to this belief that, look, football's about running the football. We're not going to throw it forward. That's crazy talk. Somebody else is just going to get it. It doesn't make sense. And the teams that embraced the new method that was available to them, they thrived. In fact, I'm pretty sure the MVP of the Super Bowl is typically a quarterback who throws the ball downfield. And so my point is, we can hold on to this idea that we shouldn't do this stuff, we should just stay put, never invest in business, and guess what's going to happen? all those states around us, they're going to continue to pull our youth out at a higher rate because they're all passing the ball forward. We can run the ball. I think you should have a balanced attack. I'm not a head coach, but balanced attack is probably a decent approach. However, you can't completely say we're not going to play this game because the game is being played elsewhere. And right now, 2 out of 3 people are leaving the state because of the opportunities that exist other places that do not exist here. And so when we look at it, we say, what tools are available to us? And our Constitution, Wyoming Constitution, says that we can invest in economic development. We should use it. We should throw the ball downfield so that we can score touchdowns for our youth. If we don't, that number won't be 2 out of 3, it'll be 3 out of 4. It'll be 4 out of 5. It'll be 9 out of 10. And then we really are making that graph even more dramatic, where the older population is going to continue to grow and our workforce is going to continue to plummet. I don't think that's an area we want to be in. And so to me, our role as government is to invest in infrastructure that unlocks economic growth in the state so that there are opportunities for our youth. We strongly believe that we have to create, and we have data that says that the Wyoming people want us to invest in job opportunities and infrastructure in our communities. And that's what this is an example of. Great question. As you can tell, I'm pretty passionate about it.
I'm going to allow about 4 more minutes of question and answer. So was there follow-up to that? Okay. Vice Chair.
Mr. Chairman, thank you. I did want to comment on the July 9th meeting. I think there was a little confusion on we wanted you to come. I do want to comment that I don't think what we requested was presented. And I think it's vital for this committee, it is for me, on grants or loans or any of that has been given to businesses or cities or whatever, the percentage of failure or success is important to me because I too agree with Senator Ide. I'm just not sure if the dollars we spend perform the way they should. You know, is that something that government should be doing?
Yeah,
So,
if you could email us specific projects that were successful or not successful, I think it'd help the committee have that perspective.
Mr. Chairman and Co-Chair Larson, the information that was provided in the document entitled, title is here, Wyoming Business Council Management Audit Committee Investments Report. You'll notice it is a 10-page document. It lists out those elements, including all of the projects in the time you're asking about. So for example, the challenge loan program, it talks about any programs that, or excuse me, any loans that were defaulted upon. It lays all of that information out there. Maybe I should have just kind of read through and highlighted some of those elements. I'm happy to answer any questions on that document. For example, I'll give you one of the bullets there is that, over the course of the challenge loan program from 2022 to 2025, these are participation loans. That means that banks and us participate together for a various number of programs. There were 279, since 1998, there are 279 loans made. That's $40 million in state funds that were loaned out. And we've collected $7.46 million in interest, and 671 jobs were created or retained. 20 loans over the course of that. So 20 loans have been charged off for a total of about 3.41% of that number. 13 of those charge-offs were loans that were issued to agribusinesses as part of the economic disaster loan program, and that accounts for about 71% of the total charge-off. So we've got all of that data, and I'm happy to walk through if you've got specific questions. And I really mean it. I want to apologize for not being here in July, but we would be happy to come back and dig deeper into these particular elements after you have some time to review it. Thank you.
Representative Lean.
Thank you, Mr. Chairman. Thank you for coming today. I think that something this committee might be interested in is in your Wyoming Business Council Board book dated September 10th and 11th in 2024, particularly pages 166 to 169, where you've got an entire list of your complete investments that you're being a business partner to. And it depends on the verbiage that we're using as to how you're correlating your answers. And I understand that you operate on many different sectors, that you're operating as a bank, that you're operating as a pass-through for federal dollars, that you're operating as an economic development program. And so I want the Wyoming Business Council to come before us and give us a broad encompassment, not here's our total dollar figures. I want to know what has lived, what has gone bankrupt, what has completed and brought us 500 jobs, 2 jobs, 17 jobs. I have probably 30 minutes of questions just from myself, and I'd be happy to email them over. One of the very first ones I would like to know is, why did we all of a sudden in 2021 and forward begin to recapture more money? Where was the recapturing process before that? How many of these funds, such as 9/11 and 24 from the hay growers, how many of them are past due? Talk to me about Plenty. I was told that Plenty didn't receive any money yet in the Laramie audit, the BRC grant. They were given $940,000. So which is it? They were given no money, or the department audit says they were given $940,000. There's a lot of conflicting moving pieces here. I'd be happy to email these questions over to you, and I'd be happy to make them public for everybody that isn't going to have time to hear them or see my email. And so with that, Mr. Chairman, I leave it to them.
Would you like to answer any one of those?
Mr. Chairman and Representative Lean, I'd love to answer them. Absolutely. I can answer some of them now. I would love that whole list of questions. The more public, the better. So Plenty did not receive state funds through the BRC program. That is not our statute or our rule. It would not pass muster with the AG for the place. I cannot tell you what that particular entity has received from other entities in the state, like the Chamber of Commerce or anything like that. It was not $940 million or $40,000, but none of those state funds have gone to Plenty as a business. That's not how that works. It cannot. We operate on a reimbursement process. So when we do a grant or a loan with a community, it must be a city, county, joint powers board, or tribal entity. Those are the only people who can apply. Any of the money that we provide to them is not given to them as a $20 million grant. Here's your money, go do what you want with it. It sits in the state coffers, and we receive an invoice for work that has been completed. We then ensure that that work is appropriate to the contract that we have with them, and then we reimburse those funds to the entity, the city, county, joint powers board, or tribal entity for services rendered. So that could be digging a trench, it could be drawing the plans, it could be doing the grading, it could be putting in the pipeline, whatever those things are, that's what we reimburse for based on the contract. The business, in this case, the one you're asking about is Plenty, did not receive BRC funds. They cannot. In the cases of every program, every dollar that is spent, as you mentioned in our board, all of those loans are listed in our board minutes, and you can see the ones that are either past due or we have written off in our board minutes for as long as I've been there, since February of 2020. In terms of why do we recapture more money now? Well, frankly, because we think it's the right thing to do. We don't think that the community should have a free pass. We believe that money should come back to the state so that we can use it in other projects. That is not only previous to I believe it was around 2018, there weren't rules or statute required for revenue recapture. Now there is, and revenue recapture only works in certain types of projects that we have begun to focus on since that time. So that's why more money is coming back. It wasn't, I don't think there's any waste, fraud, and abuse from before. I think what it was is that they were different types of projects that didn't generate revenue, therefore there's no revenue recapture. Now, there are projects that generate revenue for the community and can be recaptured. So that's been our approach for that. So I think that answers those three questions, and again, I'm happy to stand for more.
Representative Lean, follow up.
Thank you, Mr. Chairman. The one follow-up I would like to know is why are we, as a Wyoming Business Council, interceding into the free markets? Why are we acting as a bank? Why don't we force people like the House of Prayer, an evangelical church that's looking to open a daycare that was given a $995,000 loan? Why don't we send them to the bank? Why are we using public dollars to invest in the free market?
Yeah, Chairman Knapp and Representative Lean, that is just like such a perfect question. So here's why that exists. And I think if you look at that particular situation, so first of all, we are investing with a bank. So we only do participation loans to businesses. So that means a bank, another entity, is actually going with us in that loan. Now, that particular loan is called a succession loan. That loan is legislation that I believe at the time in the Minerals Committee, Representative Baer brought forth what's called the succession loan program. Now, the problem that exists, and I love the concept of the free market. It's a beautiful academic construct that doesn't exist anywhere in the world. However, what I do love is I love that there was a problem that existed in the market. And that is in our communities, again, very rural communities, our communities don't have the capacity to change ownership of a company very easily because there aren't 10 daycares, 20 daycares in the community that can absorb all those kids. And when one entity or one owner wants to retire or move along, they don't have necessarily the ability to sell to some other business. There's just, the ability is not there. So there was a gap, a financing gap. And so what this particular program does is says, look, we will co-invest with the bank because we're not going to take that risk on our own. And the bank is much better at that risk assessment. But the bank can't collateralize blue sky. They can only collateralize the hard assets of a business. And so what exists is the owners, the current owners, need to sell their business. They want to have it continue. They could just leave the town and leave them without a daycare or a mechanic shop or whatever. But we said, well, look, if we had a program, again, you can look up the legislation on this. It's back, I believe it's about 2020 is when this came into effect. This particular legislation allows a state and the bank to participate together in a loan that would never happen. So the bank wouldn't be able to loan that money. That business would not be able to succeed and to like continue to serve the community. And again, we're not necessarily kicking out another bank because we ask for, I believe it's 2 or 3 denials from banks before we loan money. So the private market, the free market, won't fix this problem. So that is the place where government can, and again, philosophies vary, but the government can provide a service in order for the community to have that business in it. Now, those loans, we will continue to report on whether they're delinquent or whether they're not paid back and all of those things, just like we do for the current challenge loans. But I think that's a great question to understand, what role does government play? Because in some places, larger communities, guess what? In Denver, Front Range, that business leaves or somebody buys it, there's no problems because those kids can be absorbed by other daycares. In Wyoming, that might be the one place. There might be a childcare desert, which we have. And so we're happy that that place existed and there is a solution for us to help that daycare continue to serve the community. So I'm glad you mentioned that one. I think it's a fantastic program that has worked well to help our smaller communities continue to thrive. Thank you.
All right, with that, if you do have more questions, I would just make sure that the committee's CC'd in and we all get the same answers. So remember I talked about decorum and not booing my time management skills. It is 12:30. Is there any public comment within or online? And we'll have 2 minutes each.
Thank you, Mr. Chairman and members of the committee. I really do mean it when I say we would love to keep coming back. If you have us on the agenda, we'll make sure we don't miss that next one. So I apologize for that. Thank you.
All right. On the subject of Wyoming Business Council, go ahead.
Yes, my name's Ross Schrickman, a citizen in Casper. I've also been a licensed insurance agent for 50 years, self-employed, so I know something about business. Government should not be in the business of business. When it comes to private enterprise, the role of government is to get out of the way, keep regulations low, keep taxes low. I looked over the materials that was presented. Just want to mention a couple things. Return of investment is very important. On page 3 of the document investments report, grants and loan awards over a 4-year period, 21 to 25, was $106 million. Potential annual impact, economic impact, $30 million. I don't use that number. I use return of investment. In the other packet on page 16 of the presentation, state investments, grants and loans, 2020 to 2023, $70 million. State revenue recapture, $22 million. So our tax dollars are being used to prop up this program. And also back on the page 3 of the investment report, jobs proposed, 567. We have 580,000 people live in Wyoming. We're only getting 0.1% return on new jobs. And I know young people are leaving, but us old people are coming here because the taxes are low and we have a good culture and we have a good environment politically. And so a lot of retirees I've met here that have come here from other places in the country, we provide economic value even though we might not be listed as jobs. I'm semi-retired, but I love this state and this community, and I like it the way it is. Any questions?
Questions? And we are glad you're here.
Thank you. And I'm under 2 minutes. Thank you.
All right. Do we still have Mrs. Bextel online?
Correct.
Okay, we have heard half your testimony. Can you sum up in 2 minutes your pertainness to the Wyoming Business Council?
Yes, Mr. Chairman, I'm hungry too. Okay, so I can see why I was going after that presentation. I just want to say that I really appreciate what Senator Ide and Representative Locke and Leon said. I 100% agree. And if you watch the Cowboy State Politics interview with Mr. Durrell, we're spending a ton of money and getting less economically stable. None of it makes any sense. I did notice on their presentation, the WCDA, I know all of y'all have read my emails where I'm just hammering the WCDA, but what we have there, and this is one of the programs that they're transitioning to, we say we're going to protect Wyoming's most vulnerable. We're going to help the poor people that live here that can't afford to live here. What we're really doing is we are creating an indentured servitude here in Teton County where you're working for some of the wealthiest companies in America. We're enabling them to pay their staff not a living wage. And the WCDA seems to, every time I public record request something, they say they don't have it. And then a month later, I get it and they've signed the document they said they don't have. A bunch of shenanigans like that. I just want to say, this is my only point, and then I'll go eat too. If you look at the WCDA's contracts with the Flat Creek Housing, remember we were told this is low-income housing under 30%, 50%, 60%. After I public record requested the documents, I noticed section 3.2.1 suspiciously changed. I went and looked at what it was filed with the county. Treatment of over-income tenants. In the event an in-place tenant, upon re-verification of the tenant's income, has a household above 80%, now remember this is all less than 60% people, AMI, the owner shall take the following action. After the initial occupancy and income determination, the tenant's household, they just pay fair market rent. So we have just given them nearly 20 million public dollars, and you don't even have to be low income to live in the building now. You're just an indentured servant for major corporations. Y'all, we need to eliminate the WCDA. No offense, Mr. Durrell, we need to eliminate the Wyoming Business Council. We're going down, not up. But I can sense in the room that things are going to change. I feel really good about it. Thank all of you for your time. Happy lunching.
Any questions? Thank you very much, and thank you for hanging on with us. Appreciate it. All right, with that, we will recess for lunch. We do have slated to come back some of those entities that were subpoenaed, and so let's try to make it back by about 1:15 so that we can get those squared away. All right, thank you. Yes, there's vending machines downstairs.